Good morning, everyone. I'm Glenn Siegel, the Special Magistrate for Code Enforcement, and this is a Charlotte County Code Enforcement hearing scheduled for July 5th. If everyone would take their seats so we can begin the meeting, please silence any electronics that you have, such as cell phones, and be aware that the microphones are on in the courtroom all the time, and this is also being televised, so anything that goes on in the course of these proceedings becomes or is open to the public. I would ask if everybody would please stand and join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. This is a quasi-judicial hearing subject to the Florida Sunshine Act, and I am prohibited from having any contact, either orally in writing or visiting sites, and I have to disclose any conflicts of interest, which I have none. This is a very important aspect of what we're about to do. If you anticipate that you're going to be giving any testimony today, would you please rise and raise your right hand so the clerk can issue the oath?
Do you swear or affirm that the testimony you're about to give today is the whole truth and nothing but the truth? If so, answer, I do. I do. Thank you.
Thank you. Please be seated. All right, we're up to agenda item 4. The next meeting date is August 2nd, 2017. Agenda item 5, agenda changes. What I have is we have an owner present for under the consent affidavits for numbers 9, 19, 24. Under new business, I have owners or representatives present for cases B as in boy, C as in Charlie, O, and I believe U. Is that correct?
That's what we understand, Your Honor.
Letter G just came out.
Okay.
He's the son of the owner.
All right, I've just been advised that under new business we have someone present on agenda case G, new business. Okay, I think we're confirmed on the agenda changes. Agenda item 7, citizen input. If you would like to approach the podium and address any of the items on the agenda, it's not your case. So if you're here for a particular matter, we'll call your case and you can address that separately. But if you have any general comments, this is the portion of the proceedings where you can approach the agenda and not only get yourself on television, but get some, make your comments that you deem appropriate for agenda items. So if anybody has anything, if they'd approach the podium at this time. All right, there being none, we'll move to unfinished business. There is none. Agenda Article 8. We have apparently a motion to vacate the findings of fact and conclusion of law, case COD 16-00458. Does county wish to make any comment on that, or?
We don't make comment, Your Honor.
All right, so I understand that you're requesting to vacate the findings of fact and conclusion of law based on the order entered May 3rd, 2017, but we're not going to hear that case today because the permit's been issued. Is that what?
If I understand correctly, the permit was issued, and now we're in that status, and we have to wait for that process to go through.
Okay, then that motion will be granted. I'm sorry?
I'm printing that out right now.
All right, I'll give you a second. While the clerk is preparing that order, I just wanted to let you know if you're here in person, I'll call your cases first so that you don't have to sit here through a rather long docket this morning, but I do have to follow certain things according to the agenda, so bear with us. Thank you. Okay, this is on the motion, but we'll have to do it in order. But we'll have to take this out, and we'll just sign it later if that's okay.
Yeah, I can do that in between while you're...
Okay, let's just do it that way. It'd be more expedient. Also, under other business, under agenda item B, Department of Health case 15-00249. It's my understanding that there is another motion to vacate the findings of fact and conclusions of law based on my order June 6, 2017, and that the payment had been made by the property owners to the Department of Health. If that's still the county's position?
That is just a lag in the paperwork, but they are in compliance.
Okay, that motion will be granted and the order will be signed. Moving on to agenda item 9. We'll start at case number 9, COD 16-1446, Frederick Rossa. If you're here on that case, please approach. I'll need to...
Yeah, the DOA.
Okay, can I see his affidavit? Good morning, Mr. Rossa. I remember who you are from our last hearing.
Good morning, sir.
Excuse me?
Good morning.
How you doing?
I have some information that I'd like to present to you.
Sure. We'll give you a full opportunity, and just bear with us for a second. We'll get started, Mr. Ross, in just a minute as soon as the clerk returns.
Use the same order. All right. We'll call Charlotte County versus Frederick Rossa, COD 16-1446. If the county's ready to proceed, your first witness, please. Officer Nicolosi.
Darcy Nicolosi, Certified Code Compliance Officer for Charlotte County. This case was presented back in July 2016. for a dock that was built, and the permit was expired, never got its finals. On May 10th, I checked the database, and the permit was expired, permit 2013-02-02838, and it had expired on January 29, 2017. And then I took photos on May 11th, and I prepared the first affidavit of noncompliance.
Your Honor, we also have the zoning official here, in case you have any questions.
All right, that's fine. If that's all you have of this witness, please call your next witness.
We'll be available for rebuttal.
Sorry,
We'll be available for rebuttal, Your Honor.
I can't.
I'm sorry, we will be available for rebuttal. We have a witness available for rebuttal.
All right, Mr. Rossi, you're on.
First of all, I'd like to present some of this information to you.
Sure, if you'd show it to council first, and then I'll take a look at it. Mr. Rossi, is that something you wish to put into evidence?
Yes, sir. Absolutely.
Your Honor, we reviewed this evidence. It appears to be a copy of Chapter 3.9 of the zoning regulations, a copy of residential dock boat lift quick permit, copy of what is marked as original permit plans. This is a copy of a Community Development Zoning Division review correction list, a letter dated February 14th, 2017 to Marianne Franks regarding the permits presumably at issue here. A second letter to Sean Cullinan, who's present, regarding the same matter, presumably. Some photographs of the property. A boat lift dock plan. This appears to be another section of the code, section 3965, boating structures. This appears to be, page 9 appears to be a picture of the canal, or excuse me, a diagram of the canal. And last page appears to be a diagram of the property. We don't have any objection to reviewing these documents, Your Honor, but we are questioning their relevance to the proceeding. Thank you.
And what I'll do is I'm going to go ahead and admit those subject to the relevancy. We'll call that respondents. Let's mark respondents A. Thank you. Mr. Rossi, do you have another copy of this? Because once I put it into evidence, I'm not going to be able to give it back to you.
I have my copy that I need to review with.
That's fine. And
Make a copy of that.
Mr. Davids, do you want to, Mr. David, rather, do you want to view this while he testifies? If you'd approach, then I'll have to look at this before I render a decision, but for right now, I'm going to, so he can follow you along. Okay, sir. That's admitted as composite exhibit A for the respondent, admitted into evidence, and you may proceed.
In that packet, you will see that the original permit was permitted, application, 3 December 2012. That permit was lost for 56 days, so I could be brought before this court, which I appeared. This actually, I believe, is the 4th appearance. On the back sheet, I have had correspondence with this county, particularly the zoning director, the code compliance, 7 or 8 times. Never got a response from those, except I received a response 4.5 months later when I requested it from the zoning official. I got it Friday.
Mr. Ross, could you hold on for a second? My pen just ran out of ink, and I want to make sure I take notes. Thank you. Sorry for the interruption. So you were saying that you heard 4 months later?
Yes, sir, from this zoning official.
Okay.
I just received the first correspondence from them. There are 3 separate identifications in the code where this permit should have been permitted. The first one, which you don't have, sir, is in the general boating at the end of the canal, where the basin in which I own, which is a copy of that within that group. It would be a lot easier, sir, if you had a copy of it.
You can just, is it something you can just show me, or do I need to?
Well, I'm assuming that they could show you, but I like
okay.
I keep mine in order.
Quick look.
It is.
Thank you.
Page 6.
Mr. Ross, is this a diagram we're talking about?
Yes, sir.
Okay.
Okay. While I'm at that, I'll give them this to approve it and show that to you also.
Your Honor, is the witness requesting that we enter this into the record? Is that what he's asking me to do?
This was part of the composite exhibit A that we've admitted into evidence.
These are actually not included in your documents, Your Honor.
Oh.
I'm just asking whether
I
he's...
have more that I would like to include along the way.
All right, so let's go ahead and, do you have...
This appears to be a photograph titled Reserve Basin 1986, and a second photograph titled Landscaped, later Seawall Dredged, Roads Paved, and All Paid For by This Taxpayer, ?
Do you have any objection to me admitting that into evidence subject to relevancy?
I do not, Your Honor, although I would like to make sure that we're focused in on the violation today, and we're not relitigating prior permit decisions of the department. That's possible.
We'll get there, but I,
Yes, sir.
I have to hear Mr. Rossa, he has the opportunity to tie this in, so. Right. Well, I'll go ahead, Mr. Rossa, I'm going to take the picture, one black and white, one color. I'll mark that as Exhibit B for the respondent. This will be subject to a relevancy objection made by the county. Please proceed.
I'd like you to look at that, sir, and
Which page?
the page that we just gave you,
The front page, the color page, start there?
color page,
Okay.
and realize that I have been at this residence for almost 37 years now, and this is what the canal looked like when I began, when I took ownership of that end of that basin. Realize that it was dredged, and the seawall was paid for, the roads were paid for, all by this taxpayer. And what I'm getting at is that on page of your first docket there, your first group, the last page, Mr. Cullinan referred to.
Am I looking at the right page?
Yes, sir.
Okay, thank you.
If you look at the right-hand side of the page, you will see the dock that is in place. It's the 19-foot-4 dock.
Yes, sir.
All the way around that corner is the property that I just showed you that I have paid taxpayer for. 40 feet all the way across the end of the reserve basin and up my residence is on the left-hand side there. The diagram shows the 45-degree angle, which the code describes should be utilized at the end of a canal. And the code, if you look at the general code, page on 5, at the end of a canal, extending a diagram at 45-degree angles from one corner to the other, where two properties share a property line, extend into the property to where the canal established a division between the two properties. Well, you can see the diagram pretty much shows exactly what that says.
Okay.
The zoning director said that I must cut this dock off 7 feet. And that 7 feet is on that diagram. You can see it where it intercepts it. Now, under the code, if I move that dock over just 7 feet, it's permitted within that triangle. And if you look at the next dotted in diagram on that particular diagram, you can see that that dock could be 26 foot 6 inches because the actual canal width there is 53 feet. Under that code. And the zoning official indicated that I'm not in compliance because of that particular triangle. As I read the code, sir, that pertains to page, let me find it. It's a copy of the code at the end of the canals with the little diagram. It's page 8.
Is it this page?
No, next one down. Next, I believe it is, sir.
This one?
Yes, sir.
Okay, I got you.
If you review the code, it says, where two properties share a property line at the end of the canal will extend to establish a division between the properties. Please take note that we are only one parcel of land all the way around this basin. This code was written and copied. At the bottom of the page of the code, you can see the dates. 4/13/15. It went to planning and zoning. I'm assuming that that is correct. I printed it from the internet. These codes, that particular code does not apply to a private owner and should not apply to a private owner who owns all the way around the end of the canal. because I have one parcel of land and pay for it. Not only paid for it, dredged it, seawalled it, been there 40 years. That's the first incidence where it is unreasonable that triangle even be utilized within this permit, because I own the whole end of that canal since 1986, I believe it is. It's a private end of the canal. The state owns that property, the canal itself. However, I do own 5 feet into the end of it, because it was, when I seawalled it, I had it taken out 5 feet to give us a little bit more basin, which matches everybody else's. I have a parcel, another thing that I would like to present to the county.
I'm sorry. Your Honor, this appears to be a shot from the Charlotte County GIS system, a photograph of a boat lift with outer dock halfway down canals, how it's marked. Owner name Diebold Viola Ferreira, and a photograph of a canal. We will recommend entrance into the record subject to the same objections.
Be so marked and admitted. We'll call it Respondent's Exhibit C. Please proceed, Mr. Russell.
If you look at that parcel, sir, you can see where it is outlined about 3/4 of the way to the end of that canal, at the end of it. And your second page will show you the dock and a elevation of that particular boat lift, which is just down my canal.
Yes, sir, see that.
What I have tried to permit here is, this is a copy of 2 parcels of land that was permitted, and under the code should not have been permitted under 5, because the dock, obviously, if you drew a triangle from those corners of that basin, that dock and lift could not be there.
Okay.
Your Honor, the respondent is requesting that you admit into evidence additional photographs from Charlotte County GIS He's marked it Basin 1 halfway down Canal Docks OVE 20 feet with bridge, 4 25-foot docks, 1 dock length. The reference of the owner is Smith Dean and G. McCauley. There's a photograph of boats in the canal. Additional photograph of boats in the canal.
Any objection to those being admitted into evidence subject to relevancy?
No, Your Honor.
They'll be so marked admitted as responded Exhibit D as in David. Please proceed, Mr. Rosso.
Your Honor, that particular dock, photographs that you have, the last ones, is adjacent to the one across the canal from the one we presented just earlier. As you can see from the photographs, there's 7 or 8 docks there. They're 30 feet, and there's one dock that runs the complete length across the corner of the basin. The second photograph, or the third one, page 22, shows a bridge across from one side to the other of the parcel. Now that parcel is owned, is one parcel. You can see it from the cover photograph.
Okay.
There's a bridge. That bridge goes from one side to the other. There's 7 or 8 docks there. You can count them 1, 2, 3, 4, 5, 6, 7 across the front of this property.
Yes, sir.
Under the provisions of the county codes, that bridge could never be built. Today's provisions. Nor can those docks be built, which is a violation of a homeowner's property rights. In that packet, after the residential boat lift and permit, the original permit, which is 20 foot, that is page 19. You can see that page.
Please proceed.
Also reference page 9 within that packet.
Okay.
Under the original permit, 2012, which was lost by this group for 56 days to bring me into this court for the 4th time. On page 2 of the codes, Article 2, man-made bodies of water. Such structures shall not extend further seaward than the lesser of 25% of the open water span. The open water span, if you'll refer to the drawing, page 9,
Okay.
is from seawall to seawall. It's an obvious, that's the open water span. My permit should have been granted under that one, that particular sentence alone. A percentage. And if you'll look up in the left corner of that page 9, you will see what the percentage is. It is a total of 245 feet, open water span. 10% of that is 24 feet. Sir, I'm only asking for 20 feet of my 40-foot width across the back of that canal. You can see it there on the diagram. That should have been granted back in 2012, sir.
Your Honor, the respondent wishes to enter into evidence a photograph from the county GIS system that he has labeled Massachusetts Ave boat lifts. There are several notations on this document, Your Honor, and a copy of the notice of dismissal in the matter of Charlotte County versus Frederick Rosa, and it's dated January 28th, 2016.
Any objection to me admitting those into evidence subject to relevancy?
No, Your Honor, we have no objection.
It's supposed to be, I think we're up to E,
E. Thank
and
you.
those will be admitted. Please proceed, Mr. Rossa.
The photograph you see there is Massachusetts Avenue Boat Basin, where you can see there are several in the plan in this particular shot. The plan, there is 1, 2, 3, 4, 5, 6, 7 boat docks, boat lifts across the back end of that canal. I measured the shortest one. It's 25 foot by 3 foot 8. The longest one is 36 feet, and that's the one in the middle. The one that is indicated there by drawing paid a tax of $27 last year. The tax on my basin was $691, excuse me, $691.87. And this county is telling me that I cannot have a 20-foot dock when I pay that kind of taxes, when those particular docks pay $27. I have seawalled it. I have paid for the roads. I have landscaped it. I think it's absurd that this goes on and on. By this code enforcement manipulating each time that I have requested an answer. I just got the last one 4.5 months after the request. And that's the first one out of about 7. Over the years, my taxes this year alone, $7,922.64 I have paid this year. Over the 30 years, I've paid this county over $200,000 in taxes. This zoning department won't let me have a 20-foot dock on property that I have paid for, landscaped, dredged, controlled the basin. There is an article in here that I don't control the basin, which I'm sure the zoning official will point out. But if you will look at what I did to that, certainly there was some control by having it dredged, and even if that statement be true, that I can't control the basin, there is no reason why that I know of, unless they have objection, that one can't have their basin dredged. As I indicated, sir, this has gone on for 5.5 years. Here's another letter that didn't come unanswered.
Your Honor, respondent wishes to submit into evidence a letter dated June 16th, 2016 regarding permit number 2013-020-2838. This kind of has no objection, subject to the relevance.
They'll be so marked and admitted, subject to the relevancy objection. Please proceed.
There are 3 separate entities that didn't make a copy of this one, so I'm going to give you half of it. I've got notes on the other half.
Your Honor, respondent wishes to enter into the record what appear to be copies, a portion of a copy of Section 3-9-65 of the Charlotte Code. We don't object to entry of the subject to the relevancy objection. Thank you.
Be marked and admitted as Exhibit G. Please proceed, Mr. Russell.
I have a couple more unanswered copies of letters that I've sent.
Your Honor, respondent requests to enter into evidence a letter to the Community Development Department dated December 2, 2014, and a second letter dated January 26, 2015. These are both to, well, the first is to the Community Development Zoning Division, second is to Code Compliance Officer Darcy Nicolosi. Same, Your Honor, no objection, subject to relevance.
Okay, they'll be so marked and admitted as Exhibit H for the respondent. Please proceed, Mr. Russell.
Your Honor, I have attempted to explain the situation briefly as much as possible. I've gone through point by point, and that last half sheet that you have there basically explains the 3 different ones. You can refer back and forth to the code to those. I don't understand why I can't have a 20-foot dock at all. The code refers to that the applicant must have control of the bottom, and I'm trying to find that particular article. But I've shown that I have control of the bottom, but that that particular statement should be relevant to marinas and basins that are dredged privately. It is a obsolete statement in the codes that should have been eliminated on that 4/13 date that it was presented to the planning board. It was not, evidently. There are many, many others that I have read into these codes that the zoning officials have put in there that are absolutely ridiculous and not looking in the aspect of a property owner perspective. And I could go through the codes and pick out many of them because I've read codes for almost 40 years. You will see that I have attempted to give you photographs, evidence, point by point, where other docks exist. And I just don't understand the manipulation of this dock procedure that has been going on for 5.5 years. I would like it to end.
Is that everything, Mr. Russell?
Yes, sir. Thank you.
Okay. The county have any response?
Your Honor, we are here today on your valid order issued on July 6th requiring the respondent to comply with Florida Building Code Section 105.4 conditions of the permit and Florida Building Code Section 110.3 required inspections. That order was entered validly. I don't think there's any dispute about that question. The respondent's testimony today and documents relate in no way to the order. The order required the respondent to comply, and that compliance is indisputably, he has failed indisputably to comply with that, with the valid order of this magistrate. So we would move to strike the testimony and move to strike the exhibits presented. We object to their relevance, and we would request that the magistrate adopt the affidavit of non-compliance and proceed as accordingly.
Your Honor.
Yes, sir.
May I speak?
Please.
If you'll look through the evidence on the request, and I didn't give you a copy of the zoning official's response. That was 4.5 months after my communication with this department. I got it Friday. In between that, the zoning or code enforcement, when the permit ran out, jumps over and has me here in this court today. I got their response Friday.
I understand. Mr. Rassa, I've got a dilemma here, and while you presented a cogent argument, and I can't say that it was not persuasive, you've obviously put a lot of research and time into this. These were the matters that were brought up at the last hearing in July of 2016, upon which my order was rendered. If you will recall that hearing, and I happen to remember that independently, is that I took the matter under advisement and looked at the documentation you submitted at that hearing, and then entered the order on that date ruling against you. And on the bottom of that order is a provision for an appeal. It says notice of right to appeal, and that advises you of your right to appeal. Now, I know that my previous ruling was not well taken by you, and I understand that, and probably got upset, and I understand that too. But from a procedural standpoint, my hands are tied. I can't change the code. I can't refuse to enforce the code when it's otherwise applicable, even if it's outdated, as you've said. But the problem that I have is procedurally. You, I'm assuming, have not appealed the prior ruling on a timely basis, and so I'm kind of stuck with what we previously ordered. I can't go back and rehear the case. The issue that brings you here today is whether or not you complied with the building permit requirements that were required by my prior order. And I wanted to give you every opportunity to present all of your evidence to make a record in case you decide to appeal today, today's decision. But I wanted you to have a full and fair opportunity to tell us why, based on my prior order, that if their violation existed. I haven't heard that. I've heard you try to re-argue your case. And as I said, it was a very cogent argument. It was well put together, and I understand and appreciate the amount of work that you put into it, but my hands are tied. And it's on that basis I'm going to have to affirm that affidavit as stated. So what you're going to need to do is, if you wish, you can appeal today's decision. You may not have had time, I mean, your appellate time may have expired, but I would certainly urge you to invest a few dollars and try to get counsel. I know you disagreed with my prior order. I understand that. And but I'm kind of locked in as that being what's called the law of the case. And so I'm affirming the affidavit based on that basis. But if you disagree, and I suspect that you do, you're welcome to appeal. I won't be offended. I think it's your right. You should do that. But based on what I've heard today, you haven't given me any reason based on my prior ruling as to whether or not, or that this particular violation didn't exist in May when Officer Nicolosi went to the property. And that's my ruling.
The prior opportunity that we had, as you recall, I did not have counsel with me.
Sure.
And I did not have counsel today also, because I have spent thousands of dollars on counsel that this group just jacked them around. And I cannot afford it. I have expended my, as I said, I've paid the taxes. I still have not paid some of my taxes, which is, if it is the county's desire to take this property, you can have it.
Mr. Ross, I want you to understand it's not that I'm not sympathetic toward you, just procedurally my hands are tied. I can't go back and undo. I don't have that legal authority to do that. And I want you to understand that. If you disagree with it, then please, I'll put, you have legal rights. And
well, obviously, I vehemently disagree with what this group has done to me.
Yes, sir.
At 78 and a half years old, I'm damn tired of it. And if you want the property, take it. Thank you.
Thank you, sir. We have all of our exhibits together.
Mm-hmm. Okay, there has been several people that has come in. Do you want me to swear in the late people?
Yeah,
Get
let's.
them all sworn in.
Right. Let's go ahead and do that, and then I'll let you tell me which cases, in which order. Do we have any legal counsel here?
No.
Okay. Ladies and gentlemen, that hearing took a little bit longer than normal. I don't believe that yours matters will take quite that long. But a number of people have come in since we started the proceedings. If that's the case, and you expect to testify, would you please stand up so the clerk can swear you in now so that we don't forget to do that? Thank you. If you'd all raise your right hand, the clerk will swear you in.
Do you swear or affirm that the testimony you're about to give today is the whole truth and nothing but the truth? If so, answer, I do. I do. Thank you. Please be seated.
Should I put my notes in there?
Huh?
Should I put my notes in this file?
I think this here is lovely head.
You what?
This one where it's lovely head.
Okay.
Okay.
All right, so.
We're going at 2-4.
Okay.
There, here.
All right, so some of the people that came in under consent affidavits, agenda item 4, COD 16-1074, Dorcas Gray. If you're here, please approach the podium. Good morning. Are you Mr. Gray?
Yes, sir, Mr. Gray. Dorcas is my wife, but she had an accident last night.
Oh, goodness. She okay?
She will be, I trust.
I wish her the best.
Yes, sir.
Mr. Gray, since you are up here probably for the first, we probably haven't been up here for a while, but the way this goes is the county will give evidence first.
Yes, sir.
And then I'll be giving you the opportunity to present your side of the case. And so, as I told Mr. Rossa, the issue is whether or not a violation existed on the date that the code enforcement officer says it was, okay? So just so that you're aware of it, please listen to the officer carefully. I know you're not going to necessarily agree with everything they say, but I'm going to give you a full opportunity to present your side, okay?
Very well, sir. Thank you.
Okay. The county is ready to proceed, please.
Yes, Your Honor. Officer Bush?
Charlie Bush, Certified Code Compliance Officer for Charlotte County. This dates back to April 5th this year that you rendered an order to clean up the lot next to him for junk-like conditions. After 15 days that you ordered, I went back there, and he still has a lot to clean up. It's getting better, but it's a lot. So.
And you went back when?
It was after the 20th. You ordered 15 days, so I believe it was like the 24th. Not sure.
Anything further from the county?
Nothing further, Your Honor.
Mr. Gray? Yes. And by the way, Mr. Gray, if you have any photographs or anything you want me to see, just let me know, okay?
I don't, Your Honor.
Okay, please, tell me what's going on.
What Mr. Bush said, I agree, but there are some circumstances. My wife's brother died in Jamaica, and we had to go down there, and we missed certain date. But I've been to, I know Mr. Bush is a very busy man. I have been to his office over there several times, that even the girls here know me. I've called, and he did call me and left a message, and I called back several times. My wife came here and called, even last week we called. But, Your Honor, we do a bit of farming there, so from time to time we bring in stuff. And I agree, Your Honor, it doesn't look as how we want to get it. But I did a hernia surgery, and the doctor said I should not do any lifting. He gave me 5 pounds and 15 pounds, but now I am working hard on it, Your Honor. I do respect his tolerance. He's a nice gentleman. I've talked to him some couple of years ago. So I am in the act of finishing up the program. What we had asked him if he would come by and shows us exactly where and what need to be done. And that was the only reason why we've been visiting his office, because we have no rebuttal against what he says, Your Honor. And also, Your Honor, I don't know if it is in your power if you could rescind the $70 fine, because it might sound small, Your Honor, but I lost my job 7 years ago. I'm just juggling. My wife is sick, and so on, Your Honor. So if it is in your power that you could, I'm guilty, but if you could do that for me, Your Honor, and I promise that I will cooperate with the county, because I've never and don't intend to have any problem with this county, Your Honor.
Well, you certainly had your share of tragedy and misfortune lately, I can tell you.
Yes, Your Honor.
Sorry to hear that, but all right. Any response to the respondent's request from the county?
No, Your Honor.
Tell you what I'm going to do, because it's for a past violation, and I know, and I don't mean to be unsympathetic, I'm going to head and confirm the $70 fine, but what I'm going to recommend that you do is maybe speak to the county, and maybe they would have the power to address this and maybe accommodate you, okay?
Very well, sir.
Okay, that's basically all I can do. I have to look at the evidence, and as I said at the beginning, the issue was the violation existent at the time You know, you've admitted that, and the problem is that while you've had a lot of personal tragedy and difficulty, I have to go based on the evidence. And
Yes.
but like I said, maybe if you're making a sincere effort, perhaps the county might be able to help you with that. Okay.
Thank you, Your Honor, and God bless you, sir.
Yeah. You too, sir.
Okay, our next one is 19.
Okay, agenda item 19, COD 16850, Jessica and Corey Collins. If you're here, if you please approach. Good morning. Are you Mr. and Mrs. Collins? Good morning. We'll follow the same procedure. The county will go first, and then you'll have a full opportunity to present your side. If you have any photographs or documents you want me to see, please have those ready, okay? All right. Please proceed.
Your Honor, we're here on affidavit of noncompliance with a valid order of the special magistrate dated February 1, 2017. Officer Roadhorst.
Good morning, Your Honor. Gary Roadhorst, Certified Code Compliance Officer with Charlotte County. I conducted an inspection following your order on May 23rd of 2017, finding outside storage of car parts, plastic, wood, and assorted other debris, and the fence was not maintained in good repair and was either falling down or supported in areas to keep it from falling down.
Excuse me. Well, when you went back, Officer Roadhorst, was there any change at all from the conditions that were originally presented at the hearing?
Yes, they had moved the trailers. They were in compliance on the property. They had cleaned up some of the debris. Although I couldn't see the chickens and the hog that were there on an earlier inspection, I could hear what sounded like a hog behind the fence, but they had repaired the fence, so I could not actually see the hog. But they had made progress on the property.
Thank you. Who wants to speak first?
Well, we don't know if you need a picture of what the back fence.
Okay, if you would, if you're going to show me a picture off your phone, it's going to be hard for me. I can consider it if there's properly, if there's no objection. But what? No. Go ahead. I just, if you want me to look at it, I'm going to ask that you show it to the county attorney first, and then I'll be happy to consider. I'm sorry.
We'll talk about it first.
Okay.
Now, when he originally came, said the trailer's 2 feet past the face of my house. It needs to be back. I had a truck in the back. The fence, which he told me was in junk-like conditions in the back. I moved the vehicle. I deeded our side lot, so I did it correctly, moved the trailer back there, so it's not up by the line of the road. It's in the back corner. I went through and repaired the broken panels. I pressure washed my fence. I stained it, re-landscaped that whole thing, and I told him I plan to do the whole thing, but we have 2 lots that are fenced. Everything takes time, everything takes money. I am making progress on it.
How far along are you with it?
I've got the whole back done. Now I have to pull a permit for the front, and then I'm going to do the 2 sides. This all started from a neighbor I didn't get along with. That guy's gone, and my buddy bought the house. And he is perfectly fine with everything there.
Do you want to offer any other testimony or evidence?
No.
Any response from the county?
Your Honor, we request that you confirm the affidavit.
Well, the county is requesting that I affirm the affidavit of a $70 fine, and I understand and appreciate the fact that you've undertaken, looks like quite a bit, toward getting the property into compliance, but there still appears to be... I'm sorry?
You see that, or you understand that?
No, I understand that. I mean, I was looking at the previous pictures that were admitted into evidence in this, and then listening to what was...
You have pictures of the fence, how it's done in the back now?
Yeah, I have the pictures that were offered, admitted into evidence at the prior hearing.
Prior to the landscaping and stuff?
Right, and so I'm just getting an idea. Well, that's what I was asking. If you have something you want me to see, if you'd show it. You want to talk about it? Okay. Well, hang on one second. Let me go ahead and...
You have additional evidence you'd like to put into evidence, Mr. Roadhorse?
Yes, I did take pictures on May 23rd, 2017. I would like to, they fairly inaccurately depict the conditions that I found. I would like to admit those into evidence.
If you just show those to Mr. and Mrs. Collins. And
I believe that'd be People's number 2. Or county number 2.
My kids' bikes.
I'm sorry?
My kids' bikes are outside storage.
Okay, well, let me first, I have some hoops I got to jump through here. Do you have any objection to me admitting those into evidence, those photographs?
It's fine, but that stuff's gone now.
Okay, we'll go ahead and mark those as County Composite Exhibit number 1. And then, Mr. Collins, if you have any photographs you want to show, please show it to the county attorney first, and I'll be happy to consider them.
I took pictures today, but the sun screwed it up, so I want a better one.
All right, well, I can't admit it into evidence, but can I borrow your phone for a second? Thank you.
And that's where that truck was parked. I'm sure you have fire pictures to that.
All right, so this is a picture for the record. It looks like an area cordoned off with some stone, has some plants in it, and it looks mulch backed by a fence. Is this the only picture you want me to see?
That's our back.
That's what I've been working on.
All right, and
As far as getting the rest of the fence is eventually going to match, but it also takes quite a bit of money.
okay, thank you. I'll return your phone to you. That looks very nice, by the way.
Thank you.
Mr. Collins, let me ask you this. The photographs that I think you can see them on the screen in front of me. What the county is saying is that that's what your property looked like when they inspected it. It came back for a follow-up inspection. And that's really what we're here about today. And so I need to hear from you whether or not those accurately depict the condition of your property when the county inspected, not...
At that date and time, yes.
Okay.
At this current, it's been loaded up and gone.
I understand. I appreciate it. It looks like you're doing a heck of a job. It really looks nice. All right, anything further, Mr. and Mrs. Collins? Okay. Anything further from the county?
Nothing further, Your Honor, except that we do appreciate the effort at compliance.
Appreciate
We appreciate the effort at compliance, Your Honor.
That's what makes my job really difficult, is when people are trying that, you know, I've got to follow the law and what the issues are, and since it's admitted that this is what it looked like on the property, I'm going to have to affirm the affidavit and the $70 fine. And I please, you know, continue with what you're doing. I hope I never see you guys again in here under these circumstances, you know, and you know, the fact that I had to do this, you know, please don't dissuade you from working on it, because it looks like
Take that much longer, because that's one bucket of stain.
No, I understand, and it does really look nice, and we certainly do appreciate the zoning department that concurs with that. Okay, sir? Thank you. Okay. Agenda item 24, Rose Marie Kluver, 163687. If you're here on that matter, if you'd please approach the podium. Now, this case, folks, is going to be a little bit different because my clerk's going to have to be sworn in and testify in the matter. So if you could please rise and raise your right hand.
Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth? So please answer.
I do.
Okay. Are you Miss Kluber?
Yes, I am.
Good morning, ma'am. How you doing?
Fine, how are you?
Okay, we're going to follow the same procedure county goes, and then if you have any photographs or documents you want me to consider, okay. If the county's ready to proceed as first witness.
Your Honor, we are here on a validly entered order of the Charlotte County Code Enforcement Special Magistrate dated March 1, 2017. The county requests that you affirm that affidavit, and we will hear from Officer Clerk. What are you? Ms. Williamson?
And for those folks in the audience and those at home that might be viewing this, Ms. Williamson was previously a code enforcement officer and then transferred back to being the clerk for the code enforcement department. So she's going back and testifying when she was. So that's what makes this a little bit unusual. So please proceed.
Please proceed.
I was there on December 2nd, and there was a lot of junk-like conditions around the property.
And now?
December 2nd.
Okay.
And there was a lot of junk-like conditions around, and we talked to your niece, was it? I talked to your niece that's living on the property at the time, and they assured me they would clean it up. They never did clean it up. I went out and did a re-inspect of the property in May, and the property was basically the same. So I did a notice of hearing, notice of violation. They came before the board.
Is there a particular day
Ms.
that you
Kluber, hang on one second. We have to do one witness at a time. I'll give you all the opportunity.
I apologize.
Thank you. Go ahead, please.
I want to make a correction on the date. On April 6th, I was there. The property still looked like in the same condition, so I did a notice of hearing, notice of violation.
Okay.
And then on May 4th, I went out, and the property still in violation, and that's when I did the affidavit of noncompliance from the board's order.
Okay. All right.
Okay. Anything further from the county?
Nothing further, Your Honor.
Okay, Ms. Kluber, keep in mind the issue is whether or not the conditions that I ruled violated the code were existent on May 4th, okay? So go ahead and talk to me and tell me what's going on.
Okay. Well, first of all, I'm not having a very good year this year. I have several problems I'm trying to relate. When she first went out there in April, I agree. It still had not been done because we were having a few problems. In May, we're starting to get back to normal at the house. We have been hauling stuff out, putting it into storage. It does not look the same. But there is some more items to be removed, which we are working on now, okay? So maybe a couple more weeks if you could give me to get this cleared up, but we have been getting rid of this stuff.
Okay, what items are still left that need to be moved?
It's way in the back. It's some kind of stuff that's been back there. I'm not sure who brought it in. It's irrelevant right now. I have to either, take it to the dump, take it to the mini transfer station. There's some wood and some junk-like items. They have to be removed. But my nephew has been moving stuff, and my niece has been, so we are working on it. We're not trying to ignore it.
All right, and those items are still there today that need to be?
Today, yes. Yes, today they're, but we are in the process of removing them.
Anything further, Ms. Kluber?
Pardon?
Any further evidence, any photographs or documents?
No, it's just we are working on getting the mess cleared up, yes.
Yeah, okay. Anything further from the county at this time?
Nothing further, Your Honor.
All right, in Charlotte County versus Rose Marie Kluver, we're here on a affidavit of non-compliance. The respondent has appeared. She has acknowledged that there is a portion of this that of the previously proscribed items on her property that have not been corrected. Some of them have since May 4th. Today's July 5th. Based on that testimony, I'm going to affirm the $70 fine and confirm the affidavit of non-compliance. That's my ruling, ma'am.
Okay.
Okay. You understand why we have to do that?
Yes, sir.
Okay. Well, hopefully you can get that cleaned up in the next 2 weeks. What's left and.
Yes, and then do I call for an inspection?
Sorry.
Do I call for an inspection at that time?
Check with the officer. You can do. You're welcome to do that, and then hopefully you don't have to come back anymore.
I certainly hope not.
Thank you, ma'am.
You're welcome.
We're going to 30 F. 30.
Okay.
It's a friend.
Okay.
Because the owner.
Okay. Agenda item 30, COD 15-1922, Mark O'Donnell. I understand that we have somebody here on Mr. O'Donnell's behalf. So if you're here, please approach the podium. Your name, please?
Deborah Vietor.
Good morning, ma'am. We're going to follow the same procedure as previously indicated, but I realize that you're not the owner, but you're a friend. Okay. All right. So we'll have the county go first if the county is ready to proceed.
Thank you, Your Honor. We're here on a valid order of the Charlotte County Code Enforcement Special Magistrate dated May 8th, 2015. And it's Officer LeBrew. No. Officer, please. Sorry.
Rhonda Leonard, Certified Code Enforcement Officer, Charlotte County. This case was brought to you October 5th, 2016. The violations were for junk conditions, an expired owner, builder, demolition permit, and some International Property Maintenance Code violations, exposed wiring, damaged exterior walls, and so forth. He did renew the permit after the hearing, cleaned up the debris, and of course it goes on review periodically. And on May the 5th, I conducted an inspection. The permit was getting ready to expire again, so I called him and I advised him he needed to get his inspections done, which he did fail the inspection. It wasn't completed. And the permit went back into expiry state on May the 10th. And the day I was there, on May the 5th, there was junk all over the place. There was still some damaged exterior walls and so forth. And that's why we're here for a one-day fine.
Anything further from the county at this time?
No, Your Honor. We requested the magistrate affirm the prior order. Thank you.
Ma'am, let me caution you first. You are free to tell me what you know from personal knowledge, but you can't represent the owner because you're not a lawyer. Well, let me ask you, you're not a licensed lawyer in the state of Florida, are you? Okay. What I don't want you to do is get yourself into trouble for practicing law without a license, but if you have personally seen the conditions and everything, then you're certainly free to tell us about that. And again, so that you know, the issue we're here about is what the condition of the property was on May 5th of this year, okay? So please.
I did do the walkthrough with Rhonda, and I went through with the whole list to fix or remove or repair everything that was on there. When it came to the exterior walls, the bottom post, I know that was not done, that was not completed. There's some technical words here that didn't understand what exactly had to be removed or replaced. There's some have to, some don't, and I'm not sure, if it was the whole thing or not. The conditions that with everything that was there was a lot of stuff. I mean, I have photos of it all now. It's all been cleaned up. It has been cleaned up for a while. Everything that was out there was trash that was going out, and that was all on the side of the house.
Do we have any photographs that were taken May 5th, or?
The photographs that I took were I put in with the affidavit of noncompliance.
Okay, I see. Okay. Would you, one of you gentlemen, oh, okay, thank you. Would you show this to the witness? Ma'am, if you take a look at those photographs, those were, the code enforcement officer says those were taken May 5th. So if you just take a look at those and let me know whether or not those accurately depict the condition of the property on May 5th.
Well, yeah, I'm assuming that, yeah, May 5th, yes, but this has been all cleaned up, and even with the house here now that she has here, the house has been painted. I did all that myself, inside out, you know, all of it. All of this stuff, just like most of this all here, was all trash that was going out and has been taken out. I have the slideshow pictures to show that, yeah, all of it's been cleaned up and removed.
Okay, I understand. If you want me to, would you show those to the county and then?
Which ones? Ours or in hers? Or?
Well, no, I'll need those back. But if you know she wants me to see the photographs, I'm happy to look at them. No, I mean the ones that she's got on her phone, apparently. Thank you.
Your Honor, the agent for the respondent is requesting that we enter into evidence photographs that are purported to be of the property at issue. There do not appear to be any dates on these photographs.
All right, well, I'll tie that up then. May I look at your phone for a minute? Thank you. All right, ma'am, what I'm looking at looks like a porch. I just lost the picture. Well, there it goes. But it looks like looked like a porch with something underneath it. Oh, thank you. That's the photograph. When was that photograph taken?
This morning.
This week, okay. Are any photographs in here taken on May 5th?
No, not that I...
Thank you. We'll go ahead and return your telephone. Is there anything else you'd like to tell us, ma'am? Okay.
That porch that you've seen, that wasn't closed lanai. That's why I showed you the picture of that, because that was all, had to be taken down. That was all done and removed.
I understand. Well, you're certainly a very, very good friend. I can say that. However, the issue is, as I said, you know, on May 5th, and you've confirmed that the photographs depicted the condition of the property at that date, which is a violation of my order, so I'm going to affirm that. Chances are, if you get that, it looks like most of it was cleaned up now, but it's like if you ran a stop sign yesterday, you know, you can't say, well, okay, I'm not going to run one for the rest of my driving career and then expect to be excused. And so that's a stupid analogy, but it's as close as I can come to what we're dealing with here. So we'll affirm the affidavit as stated, okay? Hopefully we won't have to see any of you back in there again. Thank you.
Thank you.
T. Number T, 36. I didn't mean T, but it's 36 and it's a tenant.
Okay. All right, that will take us to agenda item 36, COD 162893. And I remember this one because I couldn't pronounce the last name the first time. It's Tinny and Anastasia Fragadakis. If you're here on that matter, if you'd please approach. I'll spell it Fragiadakis. Okay, thank you, sir. All right, if you'd... your name, sir?
My name is Mr. Abear.
Abear? Okay, and sir, you are the tenant in the property?
I'm supposed to be the RTO.
Okay.
I'm on a rent-to-own program with the home.
Yes, sir.
But these tickets and these fines, the citations I'm having, are from prior to when I moved in there.
Yes, sir. Okay. All right. But we'll discuss that in a little bit.
No, I'm not a lawyer.
No. Okay.
So I'm just letting you know that, I obviously can't represent them, but they're not here.
Yeah, you're under an agreement for deed. Is that what you're telling me?
That's correct, but I never received a deed. I never received a lease, and I never received any type of...
All right. Well, you're recognized under the law as the owner, so that's the capacity that you stand in. So I'll take the county's evidence first, and then we'll hear your testimony.
Okay, because you do have the CCTV video from prior when we came here the first time.
I don't have that in front of me now.
Oh, okay. It is available, though.
It should be.
I don't have it.
It should be archived, as I understand it. So
I've been dealing with Jill Graves.
Okay.
I guess she's no longer with the company.
The county? That's correct.
That's what I've been dealing with was Jill, and this young lady flew over my house with a drone and everything else with a privacy fence.
All right,
so we'll the backyard, which is totally illegal. But
all right, well, we'll talk about that in just a minute, okay? But I got to have the county's testimony first, and
yes, sir.
And then you can explain to me what's going on, okay?
Mm-hmm. Yes,
all right, so if the county's ready to proceed, it's first witness.
Your Honor, we're here on the second affidavit of noncompliance on this property for failure to comply with a valid order of the Charlotte County Code Enforcement Special Magistrate dated October 5th, 2016. Just as an aside, Your Honor, obviously we object to the characterization of a drone flyover as illegal. That is not illegal under the state law. So we will request that Officer Leonard go ahead and bring you testify on the current status of this file. Your Honor, I apologize. I'd like to correct the record. I have a misnumbered file here. This is the first affidavit of noncompliance for failure to comply with the order of the Charlotte County Code Enforcement Special Magistrate dated November 2, 2016.
Okay. If you're ready to proceed, your first witness.
Rhonda Leonard, Certified Code Enforcement Officer, Charlotte County. This was heard by you on November 2nd, 2016 for high grass and junk conditions. The property had been cleaned up and the grass was being maintained. On April 12th of this year, I did a follow-up inspection, found that outside storage had returned. I sent a reminder letter with a copy of the findings of fact to the owners, as well as to Mr. Ebert, advising I would be doing a follow-up inspection on April the 26th, which I did, and the outside storage was still there. I ordered the abatement at that time. The abatement was completed almost a month later on May the 23rd. There are a number of photos that were submitted into the file concerning the abatement. They did have ample warning. This is a one-day fine plus the cost of abating the property.
Okay.
And for the record, no, we do not have a drone.
That's not what you told my roommate, but that's neither here nor there.
Alrighty.
Secondly, they took
Hang on,
miscellaneous
sir.
items out of my
Second,
yard.
please. I'll give you every opportunity to make your argument, present your evidence, so just bear with me. There we go. Counsel, would you take these up to the witness? Yeah, if you would. I'd like the officer to look at those. Officer, would you take a look through those photographs? And
Yes, the ones in the front were taken the day of the abatement, showing it before we did the abatement and the progress of the abatement, all the debris lined up along the sidewalk. And including photos of the clam truck removing the items, and then there were photos that were taken after the abatement, which we did leave a lot behind. But we had to do something. It was pretty bad. I also have pictures from May 22nd, April 26th, and April 12th, from when I first sent the reminder notice to them that they needed to get it cleaned up before we would order abatement, with a copy of the order.
Do those fairly and accurately depict the conditions of the property as of the date that they were taken?
Yes, they do.
All right, would you please show those to Mr. Aber? Mr. Aber, have you had a chance to look at all those photographs? Yes, sir. Do you have any objection to me to admitting those into evidence?
I want to know how they got in my carport, because you can't see my carport through my truck.
Okay. Okay. Do you have any objection to those being admitted into evidence?
The shed they took,
I think they're marked.
the Wendy's signs, I scrap metal. This is not mine. None of this is mine.
I understand some of that may not be yours, but my question is do you take your time and look through those, and just let me know if you have any objection to admitting those into evidence, and then we'll go from there, okay?
Yes, sir. I most certainly do. That's my backyard, first off. How'd you get in my backyard? Lawnmowers, I do small engine repair. I do have some objections on these photos.
And what are the objections in particular?
Can I approach, or do I got?
Oh, you can just tell me from there. And if you'd speak into the microphone, it'll be helpful. Mr. Aber, you can just put it up there, but I need you to speak in the microphone so everybody can hear you.
The one reason my carport looks the way it does is my landlord never gave me a lease, never gave me a deed. I don't want to move extra items into the home. I have accusations of false stalking charges from her here in my paperwork. I have generic states of eviction after I paid over $10,000 into the home. So, therefore, if I want to move my stuff into the home to have her close it out on me again, what sense is that? That makes absolutely no sense. But if you look at Exhibit A, this photo here, this is my vehicle here.
Yes, sir.
How do you see into my carport through my vehicle? You don't. Unless you're approaching my property, which I have no right to do. Now, on another one, my backyard. I do scrap metal. I work for Wendy's. I rebuild Wendy's stores. Wendy's gives me the signs. I bring the signs home. I strip the signs, and I bring in the Allied Recycling, and I make a couple extra dollars on them. Okay? That's nor here nor there. This shed was taken by code enforcement. I paid over $1,200 for this shed. The reason they said I can't have the shed to my roommate, which is the young lady over here, is because it's against code enforcement in the state of Florida, even though I do have anchors in the ground for the shed that were installed for the shed to be set up. If you look at the next photo, sir, none of this is mine. I've never owned an Ace wheelbarrow yet. So this picture is obviously coming from someone else's photograph in someone else's yard. Because I've never owned an Ace wheelbarrow, ever. Like I said, the weed eaters, the chainsaws, I do small engine repair. It's a side job. Half of this stuff isn't even mine. It's my client's, which half of the stuff was already thrown away, which in turn I have to reimburse my clients for all of their machines. None of this is mine. Not the thing right here is mine. As you can see, this isn't even my front yard. So where these photos are coming from, I have no clue. That, Your Honor, is that is part of the shed that was not assembled, that was rudely and abruptly taken out of my backyard and thrown away by this company. That's over $1,200 for the shed. This fish tank is $150. That was thrown away by them. I have to stand in my home for this fish tank. It never made it into the home. Reason being, once again, I do not have the lease, I do not have the deed, and I do not want to move extra stuff into the home so she can file accusations on stalking and have me evicted again. For 20 days I slept in my truck until I got the court order to state I can go back into the home. This is where they put my shed. Now, if you look at the shed photo and the dumpster photo that they have here in point A and point B, and if you go back to your photos here, none of this is in the photo of what they took out of my backyard. None of this is in the photos that they took out of my backyard. Are you understanding my point?
I'm watching. I'm looking
okay.
Where you point out.
None of which they took the shed, they took the bottom shed, they took the fish tank. That pile is a lot different than the pile in that first and second photo I showed you. This is my items. I expect to be reimbursed for my items. And the reason the carport looks the way it does is because, hey, somebody threw away my shed. Where do you want me to put it? Somebody takes my shed. Where do you put your stuff? You put it in your carport. Am I correct?
Well, sir, I can't.
It's a shed for a reason. Stepping stones, yes. Those are mine. They're on the side of my home. They're from my fire pit in my backyard. Charlotte County, in the last 4, 5, 6 months, has had a burning ban. Why build a fire pit if you can't burn? If you look in my shed is pretty organized. It's pretty cleaned out in my carport. This is the far back corner of my home. How did they get into my backyard to take pictures of my scooters that I work on? They had no reason to trespass. If you look, that's a privacy fence. That means private. In the state of Florida, code enforcement can reinforce the front yard. They have absolutely no reason to go in your backyard with a privacy fence for nothing. This was taken by a drone, according to my roommates. I was not home at the time. This is all cleaned up. That's kids' bicycles. Children's bicycles are allowed. You can't tell me my kids can't have toys. My kids can't have quads. My kids can't have four-wheelers. They can't have dirt bikes, go-karts. That's all legal. I went through this on Orange Street. I don't even know what this is. That's part of the shed, maybe? I believe. Again, privacy fence. Front yard. Absolutely nothing wrong with my front yard. They have absolutely no reason to go into my rear yard.
Okay.
Because it is a privacy fence and they have no reason to trespass. Let alone go in there and help themselves to whatever they see fit. Again, front yard. Absolutely nothing wrong with it. The yard is mowed. The yard is maintained. Once again, you can't see anything in my carport with my car there. Basically, you have no reason to walk on my property.
Sir, would you speak into the microphone, please?
But yes, sir, that's about the extent of it. And like I said, this is sections that were going into the home, but I can't bring this section into the home. Well, A, I can't now because it's all thrown away. And B, I do not have a copy of a lease. I do not have the deed to the property. I'm going to Port Charlotte, or to Punta Gorda, to the police department to file a lien on the home because this woman owes me over $10,000 for what I've done to the home so far.
Okay. Would you pass those photographs? Those photographs will be admitted as composite exhibit A for the county, subject to Mr. Aber's objection.
Would you like to see any of this other information that
yes, sir. Let me. I just a couple things I have to do here to.
Right there on the screen is my front yard. There's absolutely nothing wrong with my front yard.
All right, sir. What other documents do you have that you would want me to?
I have a generic state of eviction from this woman.
All right. You want to? If you put it into evidence, I won't be able to give it back to you. So if that, I see it. I'll get that evidentiary value to it. So.
These are all the bills that I do pay. I pay all my electricity, I pay all my water bills, I pay so on and so forth. I have all copies of all those, stating that I do exist in the home. I do not have the copy from my notary. When I did bring her to my notary, here's my original, this is our original visit here. For 214 Midway, and that was the code enforcement special, as you can see. She was here with me prior, I signed, she signed her name also. This is where she did stand here in front of the police department, in front of you, sir, and state that I am going to be the RTO rent to own on the property. Unfortunately, like I said, I never got a lease, I never got a deed, I never received anything.
Anything further?
This is her accusations on stalking charges that I went to court for, where she never showed up, which in turn gave the judge my permission that I was allowed back into the home. I can't clean stuff up, sir, if I'm not there to do it.
I understand.
I was sleeping in my truck for 20 days due to this woman. Okay, I'm still trying to fight everything else. Here's my code enforcement from Jill. Like I said, Jill Graves. I've been working with Jill now forever, trying to get this resolved. Temporary injunction for protection against stalking that she filed. The day I moved my U-Haul there, Sheriff's Department showed up. You have 20 minutes to evacuate your home. Fortunately, I have an alarm system, and she doesn't have a key. So when she said it was her home, the sheriff knew she was full of crap because she can't open a door, and she didn't know the alarm code to shut it off. So, I mean, sir, honestly, it goes on and on and on and on and on and on.
I understand, sir. You very well may have legal remedies against your landlord, if you will, that is selling.
I don't feel.
We're not here about that today.
I don't feel this fine should be mine. I believe that this fine should be going to Anastasia and Tanae because of what they're doing to me. Because they have no legal right to have me come to court to represent them because obviously they're not in the courtroom and they won't even show up. Okay? I don't feel this fine should be mine. I think this fine should go to the homeowner, which in turn is not me, because I don't have a lease. I do not have a certificate of the deed. And when you buy a home on an RTO, I'm supposed to have a copy of the deed. She's supposed to be first lien holder on the deed, and I'm supposed to have some kind of lease agreement, of which I have none of the above.
Anything further from the county?
Your Honor, the county wishes request that the affidavit on compliance be affirmed against the homeowner, Fragiaticus entity.
All right. Based on the evidence I've heard, I'm going to affirm the affidavit as stated, but you do understand that that's against Tenny and Anastasia, not you.
That is correct, sir.
So I'm affirming the violation against them, not you.
Okay, thank you.
Okay? Thank you, sir. That'll be all we need.
You have a good afternoon.
You too, sir.
Do I have to pick up any paperwork or anything?
Oh, it's okay. Thank you. I'm sorry?
Paperwork or anything?
No, it's a matter of record now. It's over.
Okay, thank you.
Today, okay?
Have a wonderful afternoon.
You too, sir. All right, it's my understanding that's the last of the people present on the consent affidavits. I'll dismiss agenda item 46. Number 17 is the lien's been paid. Number 5.
It's a Scrivener's error. He had Grums.
Okay, so we've got, okay.
Yes.
That was an error in the spelling of the name, but those affidavits will be accepted as stated, which is going to take us to new business.
Can we do these two before we?
Yeah. Agenda item 10, the first case will be BLGW 16-2 Kinsey Tillman Jr. If you're here on that, would you please approach the podium? Your name, sir? Good morning, sir. We will go forward with the evidence with the county first, and then you can present any evidence that you deem appropriate, okay? Yes, sir. Okay, thank you. The county's ready to proceed.
Officer Barnett.
Terry Barnett, Certified Code Enforcement Officer for Charlotte County. 8120 Grand Avenue is Zone BBI, Bridgeless Barrier Island. The owner of record is Kinsey Clyde Tillman Jr. The case was initiated on October 28, 2016, after code enforcement received an affidavit from Jack Boyer that the owners were in violation of Charlotte County Code 3-8-42, Section D, connection to available private potable water distribution system. I have not had any contact with the owner. The notice of violation was served in accordance with the Florida Statute 162. As of June 26, 2017, this address is still not in compliance. This concludes my testimony, and I'd like to introduce Jack Boyer. He is the custodian of record for Little Gasparilla Water Utility.
Good afternoon, Your Honor. My name is Jack Boyer. I'm the utility manager for Little Gasparilla Water Utility, a public utility regulated in 2000 once it exceeded 100 customers. Florida law required us to apply to the Florida Public Service Commission. At that time, it was the Charlotte County that regulated us, then later moved to the Florida Public Service Commission. We're simply trying to follow the rules and regulations that are regulated by the FDEP and then the Florida Public Service Commission, and now we stand before the county.
Anything further from the county?
Nothing further, Your Honor.
All right, Mr. Tillman, you heard the testimony. Can you tell me what's going on?
Yeah, we've owned a property there since 1968, 49 years. We've had a well that we've used the entire time, and we have no need for any water service. I wouldn't mind to have it, but it was my understanding it cost $5,000 to hook up to it, and therein lies the problem. We don't have $5,000.
So you've been in there since, you've owned it since 1968, you said?
Yes, sir.
Okay. Anything else you?
I've been working for the city of Tampa for 27 years, and I have a retirement plan and a deferred comp plan. I have more money than I've ever seen in my life in those plans that I cannot touch until I retire, which I was trying to make it to February of 2020, at which time I could be able to pay $5,000. But right now I've been involved with custody case, and I've been able to get custody of my grandchildren, and I just don't have $5,000.
I understand. So your current water source is the well, the original well?
Sir?
The water source currently is the original well?
Yes, sir.
All right. Anything further, sir?
No.
What I'm going to do is I want to study this a little bit more, so I'm going to take this under advisement, and I'll be taking a break in a little bit, and I'll take a look at this and I'll render my ruling. I'll just have you be notified by mail. Okay? Thank you, sir. I'm going to put this over here because I want to look at that. Okay, case COD 17-1153, Connie Snoggle. If I'm sorry if I mispronounced your name, I really do. Good morning, ma'am. How do you pronounce your name?
Eisnoggle.
Eisnoggle. Okay, I apologize.
No problem. It's not originally my name, so I don't.
Wells Fargo.
Oh, I'm sorry. Oh, A. I'm sorry. Would you mind having to see? We're going to call your case back in a minute. There's another. There's another matter I got to call first, and then I'll be right with you. Let's to free up some personnel. Let's call the Department of Health 16157 Wells Fargo Bank. County ready to proceed as first.
Officer Barnett.
Terry Barnett, Certified Code Enforcement Officer for Charlotte County. 4350 Meager Circle is Zone RSF 3.5. The owner of record is Wells Fargo Bank, N.A., as trustee for Option 1 Mortgage Loan Trust 2007-4, Asset-Backed Certificates Series 2007-4. This case was initiated on November 16, 2016, after receiving a complaint from the Department of Health that the owners were in violation of the inspection and pump out ordinance. I took a photograph of the property on March 13, 2017. The photo fairly and accurately represents the conditions I observed. I would like to offer the photograph into evidence as County Composite Exhibit 1.
There being no objection, it will be marked and admitted as requested. Please proceed.
I have not had any contact with the owners. The notice of violation was served in accordance with Florida Statute 162. July 3, 2017, Department of Health verified by email that this address is still not in compliance. That concludes my testimony. I would now like to introduce Leslie Beaucamp from the Department of Health.
You may proceed, Ms. Beaucamp.
Good morning. Leslie Beauchamp, Florida Department of Health, Charlotte County. I am the custodian of DOH records. In regards to this database, I reviewed the records for 4350 Meager Circle this morning on July 5th and found that no permits pertaining to the inspection and pump out ordinance have been issued within the last 5 years.
Thank you. If the county has nothing further, its recommendation, please.
Nothing further, Your Honor. The county recommends the respondent be found in violation of the cited code sections and be granted 30 days from the date of this order to have the septic tank pumped and inspected in accordance with Charlotte County Code, or thereafter face a fine of $100 per day for each violation that exists.
Charlotte County versus Wells Fargo Bank N.A. trustee, case DOH 1600157, pertaining to the parcel located at 6150 Golf Course Boulevard, Punta Gorda, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation and accept the county recommendation as my order. Now recall Ms. Eisennagel's case 171153. The county will go first, so I'll go ahead and call them. Okay. I see officers ready to go. Oh, do I have the file? Thank you.
Officer Nicolosi.
Darcy Nicolosi, Certified Code Enforcement Officer for Charlotte County. The property in violation is 10292 Alexandria Avenue, is zoned RSF 3.5. The owner of record is Connie Isnagel. On April 21st, based upon a complaint, I conducted an inspection of the address and observed the following violation: outside storage of lawnmowers, several flower pots, woods containers, waste management bag full of debris, and assorted other debris. A letter was sent to the owner giving 10 days to comply. A reinspection was conducted on May 23rd, and outside storage remained on site, and the grass was now in violation. During the investigation, I took photographs of the property on April 23rd and June 29th. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Composite Exhibit 1.
Will you show those photographs to Ms. Eisenagel? Ma'am, do you have any objection to me admitting those photographs into evidence? Okay, those will be marked and admitted. Please continue.
The notice of violation was sent in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance, reference the existing violations. On June 29th, I conducted the final inspection, finding some outside storage remained, and the grass was still in violation, as evidenced in the photographs. This concludes my testimony.
Anything further from the county at this time?
Nothing further, Your Honor.
Yes, ma'am.
I can't keep up with it. That's all I can say. I don't have the money to pay a landscaper. I'm trying, but my endurance just isn't enough to... I need to find somebody cheap to cut it for me.
Is there anything else you'd like for me to consider?
I don't think so. I don't.
All right. If the county has nothing further, its recommendation, please.
Yes, Your Honor. The county recommends the respondent be found in violation of the cited code sections and be granted 15 days from the date of this order to clear the zoning violations. Be granted a 2-year cease and desist order for any future zoning violations, or thereafter face a fine of $50 per day for each violation that exists. Abatement in the event of noncompliance and costs of abatement to be added to the fines and costs.
All right. Ma'am, let me ask you a question. The county's asking me to enter an order giving you 15 days to basically clean everything up. I take it that that's going to be difficult for you to do. Am I correct?
It is. A lot of it's going to depend on the weather.
All right. Well, what I'm going to do then is I'm going to essentially rule in favor of the county, but I'm going to give you 30 days instead of 15 to give you additional time. You think you can do that?
I think I can do that.
Okay, wonderful then. Okay, in Charlotte County versus Connie Eisnagel, COD 171153, pertaining to the parcel at 10292 Alexandria Avenue, Englewood, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and I'll accept the county recommendation is modified, giving you 30 days as my order. And that, okay?
Thank you.
Good luck with it, ma'am.
And Glenn, for the record, it was meager circle for Wells Fargo.
Okay.
Number A. Everything's the same except for the address. You need to correct the address.
Okay, so let me go ahead and this one's going to need to be modified.
And I'm printing it out.
Okay, that's it. And for the record, in Charlotte County versus Wells Fargo Bank, DOH 16157, the correct address is 4350 Mager Circle, Port Charlotte, Florida. So I wanted to make sure that was corrected. Ladies and gentlemen, I'd like to take a 15-minute break at this point, so if you'll just reconvene at 11:15, we'll pick up, and I promise you I'll try to get you out of here as quickly as I can. Thank you.
There you go.
It went for the supervisor election. I'm up here to the property manager. I'm up.
All right, we're back in session. I wanted to recall Charlotte County versus Kinsey Clyde Tillman Jr., case LGW 16-2. It relates to parcel ID 8120 Grand Avenue, Placida, Florida. On that matter, I'm going to find that the respondent is in violation of the charges set forth in the notice of violation. I'm going to order that he's got 30 days from the date of my order to obtain the necessary permits and connect the property to the available private potable water system, or thereafter face a fine of $50 a day for each day that the violation continues.
Heidi Gilbert is G.
Okay, thank you. In agenda item G, COD 17219, Heidi Gilbert. Ms. Gilbert, if you're here, if you'd please approach the podium. Oh, you don't look like a Heidi to me. Okay, your name, sir? Yeah. Oh, okay, thank you. The county will go. First, and then we can take yours. Okay, so bear with us, and county's ready to proceed. Its first witness.
Thank you, Your Honor. Officer Drown.
John Drown, certified.
Andre.
Officer John Drown, certified code compliance officer, Charlotte County. 600 Edmund Street is zoned RS5, residential single family. The owner of record is Heidi Gilbert. On January 30th, 2017, Officer Moore conducted a site inspection, finding outside storage described as but not limited to an ATV in disrepair, a dune buggy, jet skis, boats, trailer, metal, other motorcycles, carpet padding, inoperable vehicles, some of which were also unregistered, and the miscellaneous debris creating junk-like condition. On March 29, 2017, a notice of violation was prepared and sent to the homeowner. On June 8, 2017, a site inspection showed junk-like conditions, and the violation still existed. On June 30th, 2017, the site inspection showed that the junk-like conditions remained. I took additional photos. These photos fairly and accurately represent the conditions observed. I would like to offer these photos into evidence as County Composite Exhibit Number 1.
Those acceptable?
Yes.
Okay, those will be marked and admitted as requested. Please proceed.
I have not had contact with the property owners. The notice of violation was served in accordance to Florida Statute 162. This concludes my testimony.
Does the county have anything further?
No, Your Honor.
Sir, you want to tell me what's going on here? And I have to tell you the same warning as the other one. Unless you're a licensed lawyer, you can't really represent your mother, but you can certainly tell me about things that you have personal knowledge of, so if you wouldn't proceed.
I've been working on cleaning it up. Sorry it's been taking so long. I apologize to the county for that. It's looking a heck of a lot better than that right now.
All right. And how far along are you from completion?
15 days.
Okay. You can get it done in 15 days?
I think so.
All right. Anything further, sir? All right. County's recommendation, please.
Yes, Your Honor. The county recommends the respondent be found in violation of the cited code sections. The respondent be granted 15 days from the date of this order to clear the zoning violations. That an order, a 2-year cease and desist order be entered for any future zoning violations, or thereafter, the respondent face a fine of $50 per day for each violation that exists. Abatement in the event of noncompliance and cost of abatement to be added to the fines and costs.
So the county is requesting I enter an order giving you 15 days to clean this up, and then there's like a 2-year cease and desist order so that you don't let it get in that condition, or at least your mother doesn't. But you sure you've got 15 days will be enough?
Well, I'm going to reinspect, and I don't know if it's going to be, in compliance. Maybe a little bit more might help.
Okay.
Just in case it's not in compliance during the reinspection.
So let me do this. I'll accept the county's recommendation as my order, but I'll give you 30 days, okay?
I appreciate that, Your Honor.
I just want to make sure that you don't set yourself up to fail, that you can get that done on time, okay?
Yes, sir.
So Charlotte County versus Heidi Gilbert, case COD 17219, pertaining to the parcel at 600 Edmond Street, Punta Gorda, Florida. I find that the undisputed evidence establishes the charges set forth in the notice of violation. I'll accept the county recommendation as my order with the proviso that you have 30 days to clear the zoning violations. Okay, sir?
Thank you so much, Your Honor.
Here, you're welcome. Good luck with it. Does that change the pagination? No, okay, good.
Case is M.
Okay. Agenda item M, COD 171084, Lorraine Letourneau. If you're here, please approach the podium. Good morning, ma'am. Your name?
Hi, my name's Linda Armstrong. I'm on record. I do property management for the owner who lives up in Massachusetts.
Okay, thank you. County ready to proceed if sir witness?
Officer Letourneau? Officer Davis, excuse me.
Yeah, my name is Paul Davis, Code Enforcement Officer for Charlotte County. The location of the violation is 4037 Conway Boulevard, Port Charlotte, zoned RSF 3.5. The owner of record is Lorraine Letourneau, trustee. Okay. On May 25th, 2017, conducted an inspection of the address and observed the following violations of outside storage, including but not limited to wood, plastic bins, assorted miscellaneous items, creating the junk-like conditions and prohibited use of the property. We went there several times trying to work with the renter along with the property manager. Every time he would clean something up, then something else would show up. And then on the final inspection, not only was some of the outside storage and junk-like conditions back, but he added a car with no license plates on it toward the end. During the investigation, I took photographs of the property on April 17th, May 4th, May 25th, and June 23rd, so I did work with them a lot. These photos fairly and accurately represent the conditions I observed. I'd like to offer the photographs into evidence as County Composite Exhibit Number 1.
Oh, I don't even need to see them.
Do you have any objection, ma'am, for...
No.
Okay, those will be so marked and admitted. Please proceed, Officer Davis.
The notice of violation was served in accordance with Florida Statute 162. And then on June 23rd, 2017, I conducted the final inspection, finding the violations remained on the property. This concludes my testimony.
Anything further from the county at this time?
No, Your Honor.
Yes, ma'am.
Paul has been great. I'm between a rock and a hard place. I'm dealing with a tenant who has the mentality that he pays rent and he can do whatever he wants to do, and an owner who is physically and financially distressed right now. The tenant is moving out by August 3rd. I gave him a little leniency as a property manager because he had back surgery, neck surgery, and he was a little incapacitated. But things go away and things reappear. And that's not acceptable.
Do you think that he'll be out by August 2nd, was it? August 3rd?
His lease expires August 3rd. I've had a conversation with him. It may be sooner because now he's not paying July rent yet. But he is, I told him before he had to go. And because of his back issue after his surgery, I let him stay because things disappeared. Things got cleaned up. They looked good temporarily, but now they've reappeared again. So there is no more extensions. I'm done. He's got to go.
Assuming he vacates on August 3rd, does the owner have the ability or resources to bring this into compliance?
That would be me. And as soon thereafter, I work over at the elections office. So the following weekend when he's out is when I'll be there cleaning everything out.
And if it comes to that, how long do you think it'll take to get it cleaned up?
Get everything out to the road that weekend and then call Waste Management and have them do a bulk pickup.
Okay. Do you have anything further, ma'am? The county recommendation?
Yes, Your Honor. The county recommends respondents be found in violation of the cited code sections, that the special magistrate enter an order, a 2-year cease and desist order for future zoning violations, that the respondent be granted 15 days from the date of this order to clear the zoning violations, or thereafter face a fine of $50 per day for each day a violation exists, abatement in the event of noncompliance, and costs of abatement to be added to the fines and costs.
Well, based on the testimony, counsel, I don't think that 15 days is going to be sufficient for the lease won't even be over. So what I'll do in Charlotte County versus Lorraine Letourneau.
Mm-hmm.
It says pertaining to parcel located at 4037 Conway Boulevard, Port Charlotte, Florida. I'll accept the county recommendation, but instead of 15 days to clean up, I'll give you 30. That should give you hopefully enough time. If you run into a problem, we understand the circumstances. Just contact the county and just give them an idea of how long it will take. Okay. So we can go from there.
Okay.
Well, that'll be my ruling. Thank you.
Just let me know when it's done.
Okay, that takes us to agenda item N, COD 17-1152, Jariz Alawal. That's cutting it kind of close, but that's about as far as it. Thank you. I'm sorry, ma'am?
Various.
Jerry, okay, I apologize.
But he's in a nursing home right now.
Oh, okay.
I'm his wife.
Okay, and your name?
Christina.
Okay. How's he doing?
DCF took him out of my house. He had a stroke in the hospital when they were checking him over, and now he's in a nursing home. And he can't come home until the front door's fixed. And I was just recently told of recently made aware of a county program to help me fix that front door. She's coming out tomorrow with an inspector. She called me this morning. The county commissions called me this morning about it. I need more time. I've been splitting my time between the hospital, cleaning the house, trying to get everything in order. And he got sick in the nursing home and gave me a really bad upper respiratory infection. So there was 2 weeks I couldn't do anything.
Okay. Well, let me do this, ma'am. Let me hear from the county at first, and then we'll talk about that, okay? So if the county's ready to proceed, Officer Davis.
Thank you, Your Honor. Officer Davis.
Yeah, I'm Paul Davis, Code Enforcement Officer for Charlotte County. Location of violation, 187 Glen Ridge Avenue, Port Charlotte. Zoned RSF 3.5. The owner of record is Jariz Alawal. On June 30th, 2017, I conducted an inspection of the address and observed several violations of the International Property Code, broken windows, damage to the outside walls to make it impossible to close the door. I believe that a vehicle struck the front of the house and caused damage. There's a hole in the wall, the front wall. There's a crack that goes up. It actually cracked the front window that went with it. And then there were some other international property maintenance issues. There was some damage to the bottom parts of the house where it's starting to fall away. Some of the front part of it is starting to...
Okay. I got one witness at a time, and we'll talk about it in a minute.
And there's also some areas that where the paint is coming off some of the facade, and it looks kind of bad too. So, and then during the investigation, I took photographs of the property on April 20th, also May 12th and June 7th, and also June 30th. These photos fairly and accurately represent the condition I observed, and I'd like to offer the photographs into evidence as County Composite Exhibit Number 1. The notice of violation was served and posted in accordance with Florida.
That's right. You can go ahead and continue. It'll save some time.
Oh, she's okay. She's still looking. This house is horrible. They can't even close the door. So bad. Yeah.
Yeah, they're pretty accurate.
Yes. Do you have any objection to me admitting those into evidence?
Huh?
Do you have any objection to me admitting those into evidence? Okay, those will be so marked and admitted as requested. Please proceed.
Okay. The notice of violation was served and posted in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance, reference to the existing violations. On June 30th, 2017, I conducted the final inspection, find the violations remain the same. This concludes my testimony.
Yeah, because I can't, I'm not a contractor. I can't fix the front door.
Okay, ma'am, one second. Anything further from the county at this time?
No, Your Honor.
Okay, ma'am, would you speak into the microphone so that we can...
I can't fix the front door. I'm not a contractor.
Sure.
I've been looking for one. I've gotten 3 different estimates, 2 of which, well, no, I've gotten 1 estimate. 2 other people came out and looked and said, well, they can't do it because they weren't engineers. Because of the structural damage, it needs an engineer. So they couldn't even give me an estimate. One company never even got back to me. And the other company was strictly commercial, and their estimate was like $36,000. And I'm like, for that, I'll go buy another house. I'm not paying $36,000. I can't pay that.
I understand. This damage was caused by a car that hit the house?
My husband was driving the truck, and he hit the front door, going 5 miles an hour in 2014.
And the people that are coming tomorrow, what are they going to do? Just fix the door for you? Or
One's at a, she said it was somebody from the county. I tried to call her a couple of times back when she came out to inspect and talk to me, and she told me there was a program that she would like to get me into, but something about putting a lien on the house, because I can pay a little bit, but I can't pay a whole 20 grand at a time, you know. I have 10,000 put aside for it.
Mm-hmm.
You know, so, you know, I can pay that up front, and she said then they can put a lien on the house for the rest of it, which is fine by me, but like I said, I've been looking into it. Mm-hmm. It seems like every time I get enough money to have anything fixed, something else falls apart. Like my husband broke his hip last year.
Is there anything else you'd want me to consider, ma'am?
I just need a little more time.
Well, my biggest concern with the structural issues is that could be a safety hazard. And
But it's been that way for 3 years.
I understand.
It's gone through 5 tropical storms, half a hurricane. It didn't fall down behind me now. And now all of a sudden it's unstructurally. I mean, I know there's structural damage. I can see it. But there's 3 other entrances in and out of that house.
All right, if there's nothing further, the county's recommendation, please.
Yes, Your Honor. The county recommends the respondent be found in violation of the cited code sections. That should be granted 30 days from the date of this order to clear the zoning violations and bring the property into compliance with the International Property Maintenance Code. That a 2-year cease and desist order be entered for any future zoning violations. If the zoning violations are not cleared, that the respondent face a fine of $50 per day for each violation that exists, abatement of in the event of noncompliance, and cost of abatement to be added to the fines and costs.
What does that mean?
What they're recommending, ma'am, is that to give you 30 days to fix everything, if you can. I don't know, maybe this program might work for you, maybe it won't, I don't know. You don't know either. And then they want a 2-year cease and desist order, meaning that you're prohibited from allowing violations like that to exist again for 2 years. And that if you have future violations, they want to be able to assess a $50 a day fine against the property. Now, if you can get this fixed and everything, this shouldn't cost you anything more than the repairs. So I wanted to make sure you had enough time. So,
But if it takes longer than 30 days to fix the front door?
well, what I would say, what you could do is just have the program people recommended by the county contact the code enforcement zoning department and then see what might be able to be done for you. All right, Charlotte County versus Jerry's Elawal, COD 171152, pertaining to the parcel at 187 Glen Ridge Avenue, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and I'll accept the county recommendation as my order, but make sure that the people that come,
Yeah, she's supposed to come tomorrow morning.
all right, just make sure they're aware of the code enforcement, okay?
I'm sure they are. They're the ones that wrote the codes up.
Okay.
I mean, she's the one that, I don't know.
All right, well, good luck with that, ma'am.
Thank you.
What about O? Oh, okay. Riverstone.
Oh, okay.
All right, that takes us to agenda item O, COD 17529, Riverstone Property LLC. If you're here in that case, please approach.
Morning, Your Honor.
Gentlemen, your names, please.
Josh Kessler.
Gene Lenz.
Good morning, gentlemen. We'll follow the same procedure. County is ready to proceed. I see we have Officer Duquesne lined up.
Officer.
Andre Duchesne, Certified Code Enforcement Officer, Charlotte County. 4628 Miami Trail is Zone CG, Commercial General. The owner of record is Riverstone Property, LLC. On January 3rd, 2017, I conducted an inspection of the address and observed the following violations of the parking lot being used to display and store merchandise for sale without obtaining a special exception. During the investigation, I took photographs of the property on May 1st, June 13th, and June 2017. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Composite Exhibit 1.
Your Honor, for the record, could we get the positions with the entity for these gentlemen? Thank you.
I was going to cover that on their direct. Okay, they'll be next. Okay. All right, gentlemen, is there any objection to me entering those?
Does not look like there was a drone involved in those pictures.
Interesting issue. Okay, those will be marked and admitted. Please proceed, Officer Shane.
Courtesy letter was sent to the owner's address. I have had contact with the owner and explained to them that the violation still existed and must be taken care of to avoid further code action. Notice of violation was served in accordance with Florida Statute 162. On January 27, 2017, I conduct the final inspection, finding that the violation still existed. This concludes my testimony.
Anything further from the county at this time?
Nothing further, Your Honor.
Which of you two gentlemen is going first?
Me.
Okay, would you announce your name again and your relationship to the company?
Sure. My name is Josh Kessler. I'm the CEO of Triton Stone Group.
Okay, sir, I'm listening.
For when the pictures are in the process of as they're cleaning up, so I think some of them look better than others. I can just tell you that we rented this building with prior to us being there was a outside storage of coaches, and inside they were doing repairs. We were under the impression that we could put stuff outside. We have 3 desks, and we have 8 employees. We have 8 employees, and we average about 10 customers a day. We're a wholesale distributor of stone. So we have 191 parking spots. I understand that they had recently changed the code for outside storage. We have a 300-foot facade. Our sign you can't even really see from the road because, they made us put a 30-foot. The most we can have is a very small sign. We can't even put our full name there. We excluded basically the logo and just put Triton Stone, so we couldn't put Triton Stone Group because we didn't have enough space. And it's a shame that we can't use more outside storage during our. Obviously, we want to be compliant. I understand that I'm fairly new to the situation. These two have been talking, and that we could put some stuff outside, but only in the backyard. So was the agreement that we had.
You could put it on the front of the building outside, which would be fine on that walkway next to your building, but nothing could go in the back or in any parking spots unless you got the special exception.
I was told that we could leave it on the outside in the back.
Side of the building.
Up until 15 minutes ago, that was the understanding that I had. Also, during our moving our slabs, we had a employee. So we only have 3 guys that move slabs. They're 1,000 pounds apiece. We had a guy get his foot ran over. He was hospitalized for several weeks. Probably won't walk the same again. So we have had a little slowdown. But basically, we only have about 6 more A-frames left. We're almost completed the move. The reason I came, we're moving and we're almost done. If we hadn't had an accident, everything would have been moved. But I had we have 191 parking spots. We have 8 employees with cars. Is there anything that we could do differently to have? We have a tiny little sign. The reason we rented this place is because we have great exposure to 2 main highways. It's really essential to our business. We have 22 locations. I buy buildings or rent buildings based on, I try to be compliant, of course, and this fit our needs. This is a great opportunity for us. In our heyday, we'll probably have 20 employees, all local employees, and it's just a shame that we have such great exposure and we can't have a big sign, and we can't put our product outside. Across the street, we have a golf cart, all the golf carts all over the place. We have used car place across the street. Traditionally, our stone looks pretty nice. If we are allowed, we'll have a clean yard. We'll paint the asphalt black. We'll make it look good. If not, we'll wait till our lease is up and we'll move and we'll find a more suitable place. But it just seems a shame. And I understand we have codes, and I have a newfound respect for the the court system after listening today. It's a tough job, but we want to do good business. We want to be good tenants. We want to be good neighbors. We want to have a good looking place, and we have 191 parking spots. A huge place. We have 8 cars. What an big empty, looks like a deserted building. If we don't put something out there, is that what we want? As a community, and I don't know what else to expect or say, but.
Have you undertaken any steps to apply for a special exception?
Well, he had told me that we get 330 feet.
300 square feet.
300 square
Maximum.
feet. Yeah, so this is the special exception. We have, several acres here, and we have a 30,000 square foot building, and 300 square foot, kind of like a pimple, and this is this is silly. I mean, we have a 300 foot facade, and our sign is about twice as big as that sign, and we're 400 feet from the closest part of this main street. If you go to the corner, we're about 800, 750 linear feet to our sign. I don't wear glasses. I can't make it out.
Your Honor, just for purposes of clarity here, I want to make sure our record is clear. The gentlemen that are testifying are tenants of this facility, not the owners who are subject of this violation, just so we're clear on that. I understand they may be responsible parties, but it's not completely clear to me exactly what the relationship is, so I'd like to make sure that we have a clear record on that. I'm not trying to speak for them, but I would love to have some clarity on that. Secondly, we'd like to recognize Mr. Horton for some comments on what's been said so far.
Are you finished right now?
We have a lease to own. Option to buy.
Okay.
I need to clear the record then, too, because I dealt with Gene, and I thought he was the owner, or his company was the owner.
Okay.
My comments are kind of simple and have already been discussed a little bit. The special exception might be an option, but what you stated is what we have to deal with at this point until you go through a process that doesn't involve code enforcement, involves zoning possibly or other avenues. Those are parking stalls. They're not meant for storage of items. Okay, right now they're parking stalls. At some point maybe we can get that changed by some process, but we have to deal with that as a parking stall.
So in our stone, in our stone, we could put our stone not impeding any of the parking. We can keep the same amount of parking spots if that's what we need. But again, we have 191 parking spots. We have 8 employees. At the most, we'll have 2 or 3 customers a day. But if the parking spots is an issue, and this is what we have to deal with, I understand, we can put our stone on the side and still have parking spots. You can park right in front of the stone in the event we have a huge influx of
Your Honor, let me just stop. There's no trouble trying to ask the code enforcement manager to interpret the activities, the code activities taken, but we would steer clear from doing interpretations of the permitting process, what the potentially could be there. All those issues are not before us today and would be better discussed, and obviously in the department that is responsible for that activity. We can't give you legal opinions on whether you can do something that's not permitted there today.
Yes, basically, yeah, it comes down to that. Still, that area is zoned for a certain thing, and that type of storage by the ordinance wouldn't be one of them, and that's what needs to be further discussed. Okay?
Got me in the right direction.
All right. Anything further, gentlemen? Well, I certainly can understand the dilemma that you're in. All right. What is the county's recommendation on this?
Thank you, Your Honor. The county recommends that the respondent be found in violation of the cited code sections, that a 2-year cease and desist order for any future zoning violations be entered, that the respondent be granted 15 days from the date of this order to clear the violations by obtaining a special exception or by removing the merchandise from the parking lot and discontinue prohibited use. And if the respondent fails, that they face a fine of $100 per day for each violation that exists thereafter.
All right. What I want to do is I want to give you guys additional time. I think you got over your head when you leased the property, and you need to talk to the owner about getting a special exception at least, or to find out what your options are at this point. I'm inclined to accept the county's recommendation, but I want to give you additional time to be able to do that, see if something can be worked out for you, because I recognize its importance to your business.
We appreciate that, and Your Honor, obviously we want to get people in the door and showing. I mean, we're in business to. I mean,
I understand
business, but I understand we have to follow the codes whether we like them or not. Each slab weighs about 1,000 pounds. As you know, we've moved several thousand slabs since the original conversation. We have a few hundred to go. We're a little limited on our personnel in the course of business. It takes us about 10 minutes to pick up per slab. We have to load it on a truck, then we have to find a home for it. So we'd ask, I know that 15 days or 30 days is reasonable for you guys, but we probably need about 45 days if that's possible.
All right. Well, that's a little further than I feel comfortable doing. I have no problem giving you the 30 days, but if you're making a good effort, certainly if you keep a good line of communication as any respondent would with the county, I'm sure they're not going to drop the hammer on you if you're making a good effort. So
we've made a lot of headway so far, I think.
All right, so Charlotte County versus Riverstone Property LLC, case COD 15529, pertaining to the parcel located at 4628 MMA Trail, Port Charlotte, Florida. I'm going to accept, well, first of all, I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation. I'm going to accept the county's recommendation as my order, except I'm going to give you the additional 30 days rather, to try to figure out what you're going to do and what your resources will support and what options you have. And that'll be my order.
Thank you. Appreciate it.
Good luck, gentlemen. Okay. Now. What? That's exactly what you'd want, right? Okay. All right. That'll take us to new business agenda item S, Moonstone Holdings, 17604. If you're present on that case, if you'd approach the podium. Warren, sir, your name, please?
Josh Short.
And what relationship do you have to Moonstone?
I'm property maintenance manager for Moonstone Holdings. I'm also the tenant, the leaser for this property.
Okay, thank you, sir. We'll proceed with the county going first, and we'll take your evidence. It looks like we have Officer Leonard.
Officer Leonard.
My name's Rhonda Leonard. I'm certified code enforcement officer for Charlotte County. 3116 Crestwood Drive is zoned RSF 3.5. The owner of record is Moonstone Holdings, LLC. On March 2nd, I conducted a proactive inspection, found the following violation of outside storage of miscellaneous items, including, but not limited to, various car parts and 2 inoperative vehicles with parts missing, creating a junk-like condition, giving the appearance of major automotive work being conducted on a residentially zoned property, all creating prohibited use of the property. A warning letter was sent to the owner, giving 10 days to comply. During the investigation, I took photographs of the property on April 12th, April 24th, and June 26th. These photos fairly and accurately represent the conditions I observed. I'd like to offer these photographs into evidence as County Composite Exhibit 1.
No objection to the photos.
All right, those photographs will be so marked and admitted as requested. Please proceed, Officer Leonard.
I spoke to the tenant, Josh, on March the 9th. He said he was keeping the vehicles there until he could get them put back together, to which I advised this was not allowed on residentially zoned property. He requested an extension as he stated he was going to be out of town. I granted the 30-day extension. A follow-up inspection on April 12th found one of the vehicles removed. There was outside storage, an engine, transmission, tires, and an inoperative vehicle. I received an email from the property manager, Lee Youre. I replied with findings from this inspection. He requested additional time to contact the tenant, which I granted an additional 10 days, and I advised I would prepare the case for hearing if the violations were not corrected at that time. Reinspection was conducted on April 24th, finding no change in conditions, and there was also a trailer stored in violation of setback requirements in the front yard. The notice of violation notice of hearing was sent certified mail and was served in accordance with Chapter 162 of the Florida statute by personal delivery to Lee Youre of GNK Realty, the property manager, by Officer Nicolosi on May 19th. On June 26th, I conducted the final inspection, finding the trailer was now stored in the rear yard, but the outside storage and inoperative vehicle remained. That's the end of my testimony.
Thank you. Anything further from the county at this time?
Nothing further, Your Honor.
Yes, sir.
I just have a question. What everything is pretty much gone. The vehicle I don't plan on getting rid of, but I'd like to get some. I have something to cover it, like a carport, and you won't be able to see what's in the carport. And I just found out that I need to get a permit for that. If I could have like 30 days to get that permit, if I need to. I don't know if 15 days is fast enough for the permit to come through. But everything else in the picture is pretty much gone, and that little plant's still there.
And when did you get that? What was the date you got everything, most of that stuff off the property?
Off the top, I have no idea, officer. I mean,
the officer Leonard says that she did a final inspection on June 26th, which was maybe about 2 weeks ago.
Okay. I mean, the truck is still there. The boat's still there. The boat runs. I mean, is there anything against me having a boat in the yard? And where can I keep my trailer without being out of?
But do you have anything else further to offer? Anything else you want me to consider?
No.
Okay. What is the county's recommendation?
Thank you, Your Honor. The county recommends the respondent be found in violation of the cited code sections, that a 2-year cease and desist order for any future zoning violations be issued, that the respondent be granted 15 days from the date of this order to clear the zoning violations, or thereafter face a fine of $100 per day for each day a violation exists, abatement in the event of noncompliance, and costs. Excuse me.
All right, sir. In Charlotte County versus Moonstone Holdings, LLC, case COD 17604, pertaining to the parcel at 3116 Crestwood Drive, Port Charlotte, Florida, I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation. I'll accept the county recommendation as my order, but I'm going to give you 30 days to
Thank you, sir.
Get everything cleaned up, okay?
Okay. And
to apply for whatever you need to do, okay?
Where would I get questions answered?
You can get together with Officer Leonard and she'll explain to you.
Thank you.
Okay? That one I think is going to change your recommendation. Let's make it get up and down, that's all.
You like that, don't
Get the exercise.
I need it. Now we're on you.
You, okay. So let me give you that one back out. Sign that. All right, this takes us to agenda item U, 17890, Ruth Anderson and Stacy Parker. If you're here on that, please approach. Your name, ma'am?
Stacy Parker.
Oh, good morning. We're going to go with county first, and we'll see what we can do to help you, okay?
Officer Leonard.
My name is Rhonda Leonard. I'm a certified code enforcement officer for Charlotte County. 21106 Bursell Avenue is zoned RSF 3.5. The owners of record are Ruth L. Anderson and Stacy R. Parker. On March 31st, I conducted an inspection at the address and noted the following violations of outside storage of miscellaneous items, including but not limited to boxes, wood, container full of yard waste, an overturned table with weeds growing through, and assorted other debris, creating a junk-like condition and prohibited use of the property. The grass in the rear yard was near violation. There was also a broken window and a shed in disrepair with the roof panels coming off. During the investigation, I took photographs of the property on March 31st, May 9th, May 31st, and June 26th. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Composite Exhibit 1.
Ms. Parker, do you have any objection to me admitting those photographs into evidence?
No.
Okay. There being no objection, we'll mark those county composite exhibit 1. Please proceed, Officer Leonard.
The notice of violation, notice of hearing was served in accordance with Florida Statute 162 by posting on May 31st. Respondent was given 10 days to come into compliance with the listed violations. At the time of posting, I noted the wood on the underside of the carport roof near the front entry was rotted and in disrepair. I conducted the final inspection on June 26th, finding all conditions remain unchanged, and I've since learned that there are squatters in the residence at the time which are causing this problem. This concludes my testimony.
Anything further from the county at this time?
Nothing further, Your Honor.
Parker, would you tell me what's going on?
Last year, at the end of July, my mother lived across town, and Ruth Anderson is my mom, and she fell and she was in the hospital in the rehab for 6 weeks, and they told me she couldn't live by herself anymore. She was 85, so I had been at this house for sale for 13 and a half years, and I just grabbed my clothes and went across town and moved in with my mom to take care of her. In January of this year, she passed, and I stayed at her house, and this house was empty. Previous to her passing, we had called the mortgage company to try to sign a deed in lieu back to them because there was nobody there, and we were not going to pay for it anymore because I was at her house and couldn't afford everything. So they sent the paperwork for my mom to sign and send back, and she passed before we got that done. And so I remained at her house, and in May, I think it was May, my son was incarcerated and he got out, and I had talked to the mortgage company, and they until a deed in lieu or a foreclosure was final, I was allowed to be there. And so I allowed my son to stay there, and he did allow this couple to move in there, because I don't know where he met him or where they came from, but anyhow, he ended up going to court and going back to jail, and I had told those people then that if he goes back to jail, they got to go, and so they agreed that they would go. But come to find out that this is not the first time they've done this, because they know the squatters' laws that I didn't know, and they were kind to me, making excuses all the time that somebody stole their tools, they don't have a job, they don't have any way to go anywhere, they don't have any place to go, and I kept trying to tell them, you got to get out of here because I have to clean this house up, and I wanted to give it back to the bank. Because I had talked to them, and they were going to give me the same deal that they gave my mom to sign paperwork, but it has to be broom swept clean to be able to give it back. And so these people kept making excuses that they couldn't go anywhere, they didn't have a place to go, they didn't have a job, they didn't have money, and they knew already that if they could get to the 30-day mark, which I didn't know, that squatters' rights would come into effect, and at that time they became irrational and kind of mean to me. And there are drug addicts. There's drugs in the house. The house is demolished. They've tore interior doors off the door frames. There's drugs in there. I've had the police over there several times. At the beginning, I would come and go. I have a key. I'm an owner. I'd be allowed to do so. But the police told me, I know there's drugs in there. I know they're drug addicts. We can't do anything. And I mean, I've called their bondsmen. They're out on bond trying to get them picked up. And the bondsmen even told me that they're not complying with them, and they're not telling where they live. They're not paying their fines. They're not returning phone calls. And spoke to his boss, and his boss said, no, they can't get him. And I'm thinking, why can't they get him? I mean, I don't understand this. And I don't know. I work hard, and my mom worked for 70 years, and I don't understand people that they can have a right to just feel entitlement to be somewhere. But anyhow, I can't go there. I'm scared of them. I don't even want to go there anymore. I haven't been there for quite some time. And they both had court dates recently. I was hoping they'd go to jail. I've called the police. I've called bondsmen. I'm trying to get help somewhere to get them out of there, because I really can't afford an eviction and the whole process. And anyhow, all roads lead back to I need to evict them, and I know that now. It's going to take time. I mean, I've talked to people, and I don't have the money, for one thing. I'm trying to just get my life in order now with all my mother's things, and property taxes, homeowners insurance, the different things, and my own bills I had. And I only work at Walmart. I've been by myself for 20 years, and I'm trying to handle my own stuff. And so far, so good. But this is way over my head and beyond my wildest dreams that could even happen.
Have you, if you can't afford an attorney, have you called Florida Rural Legal Services? Perhaps they might be able to help you get rid of these people. In any event, you might want to just remember that name, because you might be able to get some help.
Yeah, okay. I called Morgan & Morgan just because I've seen them on the TV, but they said that, you know, they don't do that.
It's called Florida Rural Legal Services, and or legal aid is another name that's commonly used, so you might contact them. But we have to look at the violations as they exist today, but perhaps the legal aid folks will be able to help you get rid of these people, and you can go from there. Is there anything else that you want me to consider, ma'am?
Well, everything that you see in the pictures doesn't belong to me. It's all their stuff, and they just keep bringing and bringing. I don't know where they're... I don't understand it. I don't understand it. They had beds and stuff that were up in the wall, and then they were laying down. It was raining on everything. I mean, what's the point? I don't understand where they have all that crap and where it came from.
I understand. All right, county's recommendation, please.
Thank you, Your Honor. Regretfully, the county recommends the respondents be found in violation of the cited code sections, that they be granted 30 days from the date of this order to bring the property into compliance with Charlotte County Code and the International Property Maintenance Code, that a 2-year cease and desist order be issued for any future zoning violations. If the respondents fail to comply, that they face a fine of $50 per day for each day a violation exists, abatement in the event of noncompliance, and cost of abatement to be added to the fines and costs.
Thank you. In Charlotte County versus Ruth L. Anderson and Stacy Parker, COD 17890, pertaining to the parcel at 21106 Bursell Avenue, Port Charlotte, Florida. I find that the evidence establishes the existence of the charges set forth in the notice of violation. I'll accept the county recommendation as my order. And I'm doing that, ma'am, just so that you know, because the violations do exist. But please call the legal aid department. Perhaps you can get some help and get this fixed.
Okay, I will, but I have some questions. Last year, before my mom fell, I had made arrangements to go visit my daughter. She moved up north 4 years ago, and I haven't been there. Anyway, I canceled it because my mom needed me, and so in March and September at my job, we get very tiny bonuses, and so before all this started in March, I bought round-trip plane tickets to go, and then so I'll be gone just from a week, from July 16th right now to the 23rd. But even after I can contact somebody to help me to figure out the eviction, that's a 30-day process plus whatever extra days they give them to even get out of the house, because I can't go there until they're out. And it's going to take me another 30 days after that just to clean this up. I mean, if I have pictures of the whole situation, and if you saw it, you would understand. I mean, they have demolished and just totally ruined the whole interior. Everything is just destroyed.
Well, I understand your dilemma, and the time. I would suggest that if you find yourself in that position, you just call the zoning department and let them know what's going on, and perhaps you can work something out with them. Okay? But I don't, I've got to go on the codes for right now, but I wish you luck with it.
Thank you.
Okay.
Back at the beginning.
Okay, that's a letter. Where are you from, Georgia? All right, I think we have everybody that's appeared. Now we're just on the non-appeared parents' cases. So that takes us to number E on the agenda, COD 1645, Marcia Henry. If you're present on that case, please approach the podium. I note that no one is present on behalf of the respondent, so if the county is ready to proceed, I guess we have Officer Roadhorse, so please.
Mr. Roadhorse.
Good afternoon, Your Honor. My name is Gary Roadhorse, Certified Code Compliance Officer for Charlotte County. The location of the violation is 1323 Avalon Street, zoned RSF 3.5. The owner of record is Marcia Henry. On May 26, 2016, I conducted an inspection of the property based on a complaint finding a shed had been installed without the required permits. I took photographs of the property on May 26, June 28th of 2016, June 14th, and June 29th of 2017. These photos fairly and accurately reflect the conditions I observed. I'd like to offer the photographs into evidence as County Composite Exhibit Number 1.
All right, there being no objection, those will be so marked and admitted as requested. Please proceed.
The notice of violation was sent in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance, reference the existing violations. On June 29th, 2017, I conducted a final inspection, finding the owner had applied for the permit, but the permit was never issued. I did have contact with the owner just prior to the application for the permit. I happened to be driving by and I saw somebody out in the driveway, so I stopped by, and that's how I got contact with the owner. Since then, I've tried several times to reach him, have not been able to get any response to the door. That concludes my testimony.
Why was the permit not issued?
The permit had not gone through the process for the evaluation for the permit. The property owner never followed up to make sure that they did everything they needed to as far as the engineering requirements for wind and so forth.
Okay, thank you. If the county doesn't have anything further, its recommendation, please.
Yes, Your Honor. The county recommends a respondent be found in violation of the cited code sections, be granted 30 days from the date of your order to obtain all necessary permits and then pass all inspections in accordance with the Florida Building Code, or thereafter face a fine of $50 per day for each day a violation exists.
Thank you. Charlotte County versus Marcia Henry, COD 1645, pertaining to the parcel at 1323 Avalon Street, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and will accept the county recommendation as my order. Agenda item F, COD 162555, Rebecca Henson. If you're present on that case, please approach the podium. I note that no one is present on behalf of the respondent. If the county is ready to proceed, call your first witness.
Officer Roadhorst.
Good afternoon. Gary Roadhorst, Certified Code Compliance Officer for Charlotte County. Location of the violation is 115 Madre de Dios Street, zoned RSF 3.5. The owner of record is Rebecca R. Henson. On August 18th, 2016, I conducted an inspection of the property based upon a complaint finding a roof that was partially covered by a torn tarp and remnants of a tarp, and a section of the roof missing shingles. Since this appeared to be associated with the tornado from earlier in the year, a courtesy letter was sent to the owner. After no response to the letter and a follow-up inspection on September 9th, 2016, I sent out a letter advising of the violations. I took photographs of the property on August 18th, 2016, May 25th, and June 28th of 2017. These photos fairly and accurately reflect the conditions I observed. I'd like to offer the photographs into evidence as County Composite Exhibit Number 1.
There being no objection, they'll be marked and admitted as requested. Please proceed.
The notice of violation was posted in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance to reference the existing violations. On June 28, 2017, I conducted a final inspection, finding the tarp had further deteriorated and no repairs had been performed on the property. After posting the property on May 25th of 2017, the owner contacted me and said she'd never received any of the notices. She indicated the entire roof was in need of being replaced, and there was not enough time to do it by the hearing. I agreed to a 1-month continuance so she could either repair the roof or pull a permit for the replacement. Since the continuance, I've had no contact with the owner. That concludes my testimony.
If there's nothing from the further from the county, its recommendation, please.
Is there nothing further, Your Honor? The county recommends the respondent be found in violation of the cited code sections, be granted 30 days from the date of this hearing to bring the property into compliance with the International Property Maintenance Code, or thereafter face a fine of $50 per day for each day a violation exists.
Charlotte County versus
Henson.
Did you grab my other file? In any event, then ran off with my file. Charlotte County versus Rebecca R. Henson, case COD 162555, pertaining to the parcel at 115 Madre de Dios Street, Punta Gorda, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation and accept the county's recommendation as my order. That one. Takes us to agenda item I, Become We College Fund LLC, COD 17684. If you're present in that case, please approach the podium. I note that no one is present on behalf of the respondent, so Officer Brown.
Your Honor, just I noticed that there's an item H. Did we handle that already, or has that been pulled? Or
Sherman, it's been pulled.
Okay, I'm sorry. I didn't have that. Okay. Officer Brown? Officer.
Thank you. The violation address is 11330 6th Avenue, COD-17-00684. Officer John Drown, Certified Code Compliance Officer for Charlotte County. 11330 6th Avenue is owned RSF5, residential single family. The owner of record is Benacawam College Fund LLC. On March 17th, 2017, Officer Williamson conducted a site inspection, finding car parts, engine parts, wood, lawn, and assorted debris. Officer Williamson placed a code compliance request on the property, given 15 days to correct the violation. On June 9th, I conducted a site inspection, finding violations still existed, and took photos. Again, on June 30th, 2017, a site inspection showed violations still existed, and I took photos. These photos fairly and accurately represent the conditions I observed. I would like to offer these photos into evidence as Charlotte County Composite Exhibit Number 1.
Those will be so marked and admitted as there's no objection. Please proceed.
I've had no contact with the property owners. The notice of violation was served in accordance with Florida Statute 162. This concludes my testimony.
Nothing further from the county. It's a recommendation, please.
Yes, Your Honor. The county recommends the respondent be found in violation of the cited code sections, be granted 15 days from the date of this order for clearing violations, and an order, 2-year cease and desist order be entered against for any future zoning violations, or thereafter face a fine of $100 per day for each day a violation exists, abatement in the event of noncompliance, and cost of abatement to be added to the fines and costs.
Thank you. In Charlotte County versus Bonackwami College Fund LLC, 17684, pertaining to the parcel at 11330 6th Avenue, Punta Gorda. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and have accepted the county's recommendation as my order. Okay. Takes us to agenda item K, COD 17474, Mary Hargraves and Philip Hargreaves. I note that no one is present on behalf of the respondent, so if the county is ready to proceed, it looks like we have Officer LaRue teed up for this.
Chris LaRue, Charlotte County Code Enforcement. 840 Palmetto Drive is zone residential single family. The owner of record is Marie and Philip Hargreaves. On February 17, 2017, I conducted an inspection of the property and found outside storage in junk-like conditions consisting of, but not limited to, a fish tank, gas cans, scrap lumber, scrap tile, and other items, creating a junk-like condition and a prohibited use of the property. I met with the owner of the property on March 6, 2017 and discussed the violations with her, as well as drafting a letter on March 13, 2017, which was mailed to the owner outlining the violations. During the investigation, I took photographs on March 6th, March 13th, May 1st, and July 3rd. These photographs fairly and accurately represent the conditions I observed. I would like to enter these photographs into evidence as Charlotte County Composite Exhibit Number 1.
There being no objection, it'll be marked and admitted as requested. Please proceed.
Notice of violation was served in accordance with Florida 162. I have had personal contact with the property owner on 2 different occasions. On July 3rd, 2017, I conducted my final inspection, finding the violations still exist. This concludes my testimony.
The county has nothing further. Its recommendation, please.
Nothing further, Your Honor. The county recommends the respondents be found in violation of the cited code sections, that a 2-year cease and desist order be entered for any future zoning violations, that the respondent be granted 15 days from the day of this order to clear the zoning violations, or thereafter face a fine of $50 per day for each day a violation exists, abatement in the event of noncompliance, and costs of abatement to be added to the fines and costs.
Thank you. Charlotte County Marie and Philip Hargreaves, COD 17474, pertaining to the parcel located at 840 Palmetto Drive, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation and accept the county recommendation as my order. All right, that takes us to agenda item L, COD 17842, Robert and Mary Crane. I note that no one is present on behalf of the respondent. If the county is ready to proceed, looks like we have Officer Davis.
Officer Davis.
Paul Davis, Code Enforcement Officer for Charlotte County. Location of violation was 233 Rockwood Street, Port Charlotte, zoned RSF 3.5. The owner of record is Robert L. Crane and Mary Ann Crane. On May 22nd, 2017, I conducted an inspection of the address and observed the following violations of an inoperable vehicle with expired registration parked in the yard, creating junk-like conditions and prohibited use of the property. During the investigation, I took photographs of the property on May 8th, May 22nd, and June 8th, 2017. These photos fairly and accurately represent the conditions I observed. I'd like to offer the photographs into evidence as County Composite Exhibit Number 1.
Those will be so marked and admitted. There being no objection, please proceed.
The notice of violation was served in accordance with Florida Statute 162. On June 8, 2017, I conducted the final inspection, find the violation remains the same. This concludes my testimony.
If the county has nothing further, its recommendation, please.
We have nothing further on. The county recommends the respondents be found in violation of the cited code sections, that a 2-year cease and desist order be entered for any future zoning violations, that the respondent be granted 15 days from the date of this hearing to clear zoning violations, or thereafter face a fine of $50 per day for each day a violation exists, abatement in the event of noncompliance, and costs of abatement to be added to the fines and costs.
Thank you. In Charlotte County versus Robert and Mary Ann Crane, COD 17842, pertaining to the parcel at 233 Rockwood Street, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation and accept the county recommendation as my order. That takes us to case P, COD 17865, Ronnie and Jill St. Louis. I note that the respondents are not present, so if Officer Bush is ready to proceed, please do so.
Good afternoon. My name is Charlie Bush. I'm a certified code enforcement officer for Charlotte County. 14435 Woodstock Road is zoned MHC Mobile Home Conventional, the owner of record, Ronnie and Julie St. Louis. On July 5th, 2017, based on a complaint, an inspection at the address observed the following violations: broken windows, an open sliding door, rotted wood, and high grass. During the investigation, photographs of the property were taken on March 28th and May 4th. These photographs fairly and accurately represent the conditions I observed. I'd like to offer the photographs into evidence as County Composite Exhibit 1.
All right, those will be so marked and admitted since there's no objection. Please proceed.
Notice of violation was posted in accordance of Florida Statute 162, and the respondent was given 10 days to come into compliance, referencing the existing violations. On June 28th, I conducted the final inspection, finding the grass was still high. All other conditions remain the same. That concludes my testimony.
County has nothing further. Its recommendation, please.
County has nothing further, Your Honor. The county recommends respondents be found in violation of the cited code sections, that a 2-year cease and desist order be entered for any future zoning violations, that the respondent be granted 30 days from the date of this hearing to clear the zoning violations and bring the property into compliance with the international property maintenance codes, or thereafter face a fine of $50 per day for each day a violation exists. Abatement in the event of noncompliance and costs of abatement to be added to the fines and costs.
Thank you. Charlotte County versus Ronnie and Julie St. Louis, COD 17-865, pertaining to the parcel at 14435 Woodstock Road, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation and accept the county recommendation as my order. Excuse me. Agenda item Q, COD 17-1376, Yelena Shabili. I note that no one is present on behalf of the respondent. Looks like we have Officer Bush ready to go, so.
My name is Charlie Bush. I'm a certified code enforcement officer for Charlotte County. 108 Corey Street is zoned RSF 3.5, and the owner of record is Yelena Shabili. On May 9th, 2017, based on a complaint, an inspection on the address observed the following violation: dual wheel semi parked in the driveway. During the investigation, I took photographs on May 9th, 2019. The photographs fairly and accurately represent the conditions I observed. Would like to offer these photographs into evidence as County Exhibit number 1.
Thank you. It's just the one day that you took the photographs?
Yeah, there's 2 different photographs. One's prior as a repeat offender, but I did not take that. It was from another.
Okay. I got it. All right, the county recommendation, please.
Yes, Your Honor. The county recommends the respondent be found in violation of the cited code sections, that a 2-year cease and desist order for any future zoning violations be entered, that the respondent be granted 15 days from the date of this hearing to clear the zoning violations, and or thereafter face a fine of $50 per day for each day a violation exists. Abatement in the event of noncompliance and cost of abatement to be added to the fines and costs.
All right, Charlotte County versus Yelena Shabili, COD 17-1376, pertaining to the parcel 108 Corey Street, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and I've accepted the county recommendation as my order. Agenda item R, COD 17-1425, Richard and Sean Dudane. I note that no one is present on behalf of the respondent, so Officer Bush.
My name is Charlie Bush. I'm a certified code enforcement officer for Charlotte County. 10181 Winston Avenue is zoned RSF 3.5, and the owner of record, Richard and Sean Dodane. And on May 13th, 2017, based on a complaint, an inspection at the address observed the following violation: dual-wheel truck parked in the driveway. During the investigation, photographs of the property were taken on September 29th, 2015, November 14th, 2015, and May 13th, 2017. These photos accurately and fairly inaccurately represent the conditions I observed. I would like to offer the photographs into evidence as County Exhibit 1.
Those will be so marked and admitted as there's no objection. Please proceed.
Notice of violation was posted and was served in accordance to Florida Statute 162. Respondent was given 10 days to come into compliance referencing existing violations. On June 28th, I conducted final inspection, finding a dual-wheel truck was removed, but due to repeat offender, I'd like to have the cease and desist added to it. Please.
All right, if the county has nothing further, its recommendation, please.
Nothing further, Your Honor. The county recommends the respondents be found in violation of the cited code sections, that a 2-year cease and desist order be entered for any future zoning violations, that the respondent be granted 15 days from the date of this hearing to clear the zoning violations or thereafter face a fine of $50 per day for each day a violation exists, abatement in the event of noncompliance, and cost of abatement to be added to the fines and costs.
Okay, Charlotte County versus Richard and Sean Dodane, COD 171425, pertaining to the parcel at 10181 Winstead Avenue, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation and accept the county's recommendation as my order. Takes us to agenda item T, COD 17805, Robert and Elizabeth Markstein. I note that no one is present on behalf of the respondent, and I see that we have Officer Leonard on this one, so.
Officer Leonard,
proceed.
We're prepared for your testimony.
We're looking, doesn't appear that the photos are on the PowerPoint for some reason. Apologize for that. My name's Rhonda Leonard. I'm a certified code enforcement officer for Charlotte County. 3112 Easy Street is zoned RSF 3.5. The owners of record are Robert and Elizabeth Markstein. On March 23rd, in reviewing a previous case, I noted the property was sold to a new owner. Conducted an inspection at the property and found the following violations of outside storage of miscellaneous items, including but not limited to multiple chlorine jugs, pavers, plastic containers, pallets, wood, cabinets, and assorted other debris, creating a junk-like condition and a prohibited use of the property, and a 6-foot wood fence installed without a permit. A warning letter was sent to the owner, giving 30 days to comply with the listed violations. During the investigation, I took photographs of the property on April 26th and June 28th. These photos fairly and accurately represent the conditions I observed. I would like to offer these photographs into evidence as County Composite Exhibit 1.
There being no objection, they'll be marked and admitted as requested.
A review of permitting on April 26th found a fence permit had not been applied for. A site inspection found there was also an 8-foot section of fence installed at the front and side of the property. The outside storage remained. The notice of violation, notice of hearing was sent certified mail and was served in accordance with Chapter 162 of the Florida statutes. On June 28th, I conducted the final inspection, finding no change in conditions as evidenced in the photos. Review of permitting found a fence permit had not been applied for. That's the end of my testimony.
Thank you. If the county has nothing further, its recommendation, please.
Nothing further, Your Honor. The county recommends respondents be found in violation of the cited code sections, that a 2-year cease and desist order for any future violations be entered, that the respondents be granted 15 days from the date of this hearing to clear the zoning violations and obtain any necessary permits to bring the property into compliance, or thereafter face a fine of $100 per day for each day a violation exists, abatement in the event of noncompliance, and cost of abatement to be added to the fines and costs.
Thank you. In Charlotte County versus Robert and Elizabeth Markstein, COD 17805, pertaining to the parcel at 3112 Easy Street, Port Charlotte, Florida, I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation and has adopted the county recommendation as my order. Takes us to agenda item V. Victor, COD 17945, Harry Cubis. I note for the record that no one is present on behalf of the respondent. So we have Officer Leonard.
Officer Leonard.
My name is Rhonda Leonard. I'm a certified code enforcement officer for Charlotte County. 21195 Gladys Avenue is zoned RSF 3.5, and the owner of record is Harry R. Cubis. On April 6th, I conducted an inspection, found the following violation of outside storage of miscellaneous items, including but not limited to items under a tarp in the front yard, creating a junk-like condition, and appeared to be getting ready for a yard sale again. Follow-up inspection on April 28th found the items removed from the front yard, now stored in the side yard, and included boxes, bins, items under a tarp, and assorted other debris. A warning letter was sent to the owner, giving 10 days to comply. During the investigation, I took photographs of the property on May 16th and June 26th. These photos fairly and accurately represent the conditions I observed. I'd like to offer these photographs into evidence as County Composite Exhibit 1.
Those will be so marked and admitted. As there's no objection, please proceed.
Follow-up inspection on May 16th found the outside storage remained, and I noted a damaged exterior door. Notice of violation, notice of hearing was sent certified mail and was served in accordance with Chapter 162 of the Florida statutes. On June 26th, I conducted the final inspection, finding the door remains in disrepair and the outside storage across the front and side yard. That's the end of my testimony.
Thank you. County recommendation, please.
Thank you, Your Honor. The county recommends the respondent be found in violation of the cited code sections, that a 2-year cease and desist order for any future violations be entered, that the respondent be granted 30 days from the date of this hearing to clear the zoning violations and bring the property into compliance with International Property Maintenance Code, or thereafter face a fine of $50 per day for each day a violation exists, abatement in event of noncompliance, and cost of abatement to be added to the fines and costs.
Thank you. Charlotte County versus Harry Cubis, COD 17945, pertaining to the parcel at 21195 Gladys Avenue, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation and accepted the county's recommendation as my order. Takes us to agenda item W, COD 17952, Pierre and Linda Jean Forrester, trustees. I note that no one is present on behalf of the respondent. So we have Officer Leonard.
Officer Leonard.
My name is Rhonda Leonard. I'm a certified code enforcement officer for Charlotte County. 3460 Croton Terrace is zoned RSF 3.5. The owners of record are Pierre P. Forestier, Linda Jean Forestier, and Michael Cullen, all as trustees. On April 6th, I conducted an inspection, found the following violation of outside storage of miscellaneous items, including but not limited to an armoire, furniture, buckets, shop vac, bins, gas cans, plastic containers, a tank, and a soil of debris, creating a junk-like condition, and a trailer stored in violation of setback requirements, all creating a prohibited use of the property. During the investigation, I took photographs of the property on April 6th and June 29th. These photos fairly and accurately represent the conditions I observed. I'd like to offer these photographs into evidence as County Composite Exhibit 1.
Those would be so marked and admitted.
The notice of violation, notice of hearing, was served in accordance with Chapter 162 of the Florida statutes and was prepared as a recurring offender due to previous cases for the same violations. On June 2nd, I met with Mr. Forestier and the tenants on site. There was still a lot of outside storage. I was told they were installing new tile and kitchen cabinets, and is why there were so many household items in the yard and had nowhere else to put things until the project was finished. I continued the case until June. I conducted the final inspection on, I continued the case till July, my apologies. I conducted the final inspection on June 29th, finding most of the outside storage was removed. There were still bins, moving blankets, plastic tank, and assorted other debris. That's the end of my testimony.
Thank you. County recommendation on this?
Thank you, Your Honor. The county recommends the respondents be found in violation of the cited code sections, that a 2-year cease and desist order for any future zoning violations be entered, that the respondent be granted 15 days from the date of this hearing to clear the zoning violations, or thereafter face a fine of $100 per day for each day a violation exists, abatement in the event of noncompliance, and cost of abatement to be added to the fines and costs.
Thank you. Charlotte County versus Pierre and Linda Jean Forrester, KCOD 17952. Pertaining to the parcel at 3460 Croton Terrace, Port Charlotte, Florida, I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and have accepted the county's recommendation as my order. I think this is the last case, agenda item X, COD 171210, Youre Pearson. I note that no one is present on behalf of the respondent. The charge is set forth in code 3-9-5B will stand dismissed at the request of the county.
Yes, Your Honor. Officer Leonard.
My name is Rhonda Leonard. I'm a certified code enforcement officer for Charlotte County. 21543 Kenyon Avenue is zoned RSF 3.5. The owner of record is Youre Pearson. On April 26th, I conducted an inspection and found the following violations of outside storage of miscellaneous items, including but not limited to wood, bins, shopping cart, items under a tarp, and assorted other debris, creating a junk-like condition and prohibited use of the property. During the investigation, I took photographs of the property on May 10th and June 26th. These photos fairly and accurately represent the conditions I observed. I'd like to offer these photographs into evidence as County Composite Exhibit 1.
Those will be marked as and admitted as requested. Please proceed.
A warning letter was sent to the owner, giving 10 days to comply. Follow-up inspection on May 10th found outside storage now being stored in an 8-foot dog kennel that was installed without a permit. Notice of violation, notice of hearing was served in accordance with Chapter 162 of the Florida statutes. I conducted the final inspection on June 26th, finding the kennel removed. A lot of debris was removed, but there was still furniture, a shopping cart, wood, tarp, and assorted other debris. That concludes my testimony.
Thank you. County's recommendation on this?
Thank you, Your Honor. The county recommends the respondent be found in violation of Code Sections 3-9-33E Echo and 3-9-76. That is 2-year cease and desist order for any future zoning violations to be entered. That the respondent be granted 15 days from the date of this hearing to clear zoning violations, or thereafter face a fine of $50 per day for each day a violation exists. Abatement in the event of noncompliance, and cost of abatement to be added to the fines and costs.
Thank you. Charlotte County versus Youre Pearson, case COD 171210, pertaining to the parcel located at 21543 Kenyon Avenue, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and have accepted the county recommendation as my order. We're in agreement. That concludes all of the new business cases. All right, then that takes us to agenda item 11, staff and citizen input on any subject.
None from the county attorney's office, Your Honor.
All right, then we'll stand in adjournment. Thank you.